Maybe for listing Muller 3 meters Muller. Developers. It was allowed.
Item 1 for motion.
And father's name is Kosimuddin Akant.
Sorry.
Kosimuddin Akant.
Kosimuddin
Akant.
Akant. Which page?
Petitioner name is Abdul Aziz.
I
Aziz
know.
Ali.
No, fathers, which page?
Page 16, my lord.
60.
Here is my lord. I don't know, my lord, original voter list. Serial number 279.
279, Kasimuddin Akant.
Yes, Kosimuddin.
Son of Palan.
Yes, Palan Akant. And next page, my lord. Page
66.
18, my lord.
Hmm.
Here is Aziron Nesa.
Gaon is Abora Rivita. Yes.
Aziron Nesa is mother, my lord.
It's okay. Now, what is the link with
Page
Abdul Aziz?
23.
Sorry.
Page 23.
23.
23, my lord. Bottom left side, serial number 132, 133.
Yes.
137.
Kasimuddin, son
Yes.
of Palan Akant.
Yes. Aziron Nesa,
Gaon Nam
Kosimuddin,
Ravita,
Aziz Ali,
Aziz Ali. This is the voters list of
93.
1993. You produce all the in-between voters list, then go back.
Yes.
Third, Mr. Motin, yes, really the same. Also heard.
Here's one for to mention in another document, Mr. Pai.
May record this.
আহে যদি নিলিখিব নাই যদি নিলিখিব
He is kept.
there is nothing called proxy in a court of law by referring to the file. Yes, yeah, the petitioner Abdul Aziz had been referred
Page 16.
to the Foreigners Tribunal number. Where is that order of the tribunal?
Page 51, my lord.
51.
Page 51.
51. Had been referred to the Foreigners Tribunal number 4, Gwalpara,
Gwalpara.
for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971 from the specified territory. Resulting in registration of FT case number FT bracket G41065/2016. The tribunal rendered an opinion dated 29/6/2018 that the petitioner is a foreigner being aggrieved district petition is instituted. The petitioner relies on the voters list of 1966 of village 131 number Abrar Bhita police station Lokhipur in the Gwalpara district, which contains the name of
Kosimuddin, actually, my lord. Now.
Kumunuddin Akant. Kumunuddin Akant.
Kumuddin, my lord. Page 16 is the original.
Kusumuddin Akant. But the English translation is Kumunuddin, Mr.
My lord,
Moti.
page 16, it is Kumuddin. Page 16 is the vernacular.
Page
It's not
16.
Kusumuddin, it is Komumuddin,
Yes, my lord.
Actual name is Kosumuddin.
whatever it is. Komumuddin Akant, son of Palan Akant, at serial 279, where the name of Gaduli Khatun is shown to be his wife at serial number 281.
I know.
Full stop. The petitioner thereafter
Page 18.
refers to the voters list of 1977 of Mr. Motin. Mr. Motin, if you have not completed your argument,
Page 18, my lord.
Mr.
Page 18.
Motin, if you have not completed your argument, you can continue so.
Page 18, my lord, kindly.
But
see.
while you are dictating the order, please don't. Please don't interrupt when we are dictating the order. And if you have not completed your argument, we allow you to complete it. People. No, 1993 of village 131 Abravita under police station Gwalpara. About to Lokhipur Nasil Jana. PSP बहुत लिया से समझो ना एक आपको भूल के लिए से हाँ ना Gwalpara हाँ page 23 23 कम तो पर वो से है कौन है हाँ ना Gwalpara और इंग्लिश कोड के मिले A2 305 April this time. Hanga Lokhipur. Ekon say 131 April this time. Mr. Pine
My lord.
or Election Commission, where is Mr. Ali? Come to page 16.
1-6, my lord.
Come to the vernacular one, because
Yes.
the English translation is not always
Page 16, my
what
lord.
it ought to be. Voters list 1966. Okay.
Yes,
Gaon 305 Abrar Bhita. Thana Lokhipur. Now come to page 23. Gaon 131 Abra Bhita. Name is same.
yes,
Thana Lokhipur, Gwalpara.
yes.
Police station is Gwalpara.
Circle same, Balijan.
Is it the same village or it's a different village? Because in these places, there are a number of villages having the same name. It's quite common. As the police station is different, is it the same village or it's a different village?
I have to ascertain, my lord. I can.
Mr. J. Paying, Land Counsel for the Home Department, seeks for an adjournment to provide the information as to whether 305 Abravita village, 305 Abravita under police station Lokhipur, corresponding to the page 16 voters list of 1966, and the village 131 Abravita, police station Gwalpara, corresponding to page 23 voters list of 1993, are the same village. List after a week.
Item 2 and 3.
Yeah, it total Thana Bhuban.
My lord, 2 and 3, my lord, Dipankar Nath.
Can we have the revenue department? Anyway, we'll need him after 1 or 2. Yes, where is revenue department?
My lord, informed, they have been informed, my lord. Somebody will come, my lord.
Dot Pujari Gamya. That's it.
Yes, today we need the revenue department. We have one series matter also later on. So for that one, we definitely need the revenue. How can we do that?
Item 4 for admission.
Whom do you appear? Mr. Das, for whom do you appear?
My lord, for the government, my lord.
Government
Not
means
for the agriculture, my lord, for the home department, my lord.
you appear for the home department. Okay.
Agriculture is there, my lord.
Where is the petitioner? I think on the last occasion, we passed some order.
Yes, sir.
What are the statistical information in compliance of that order?
Lordship, I have given two bonds, Lordship. One is with regard to the decision and the subsequent implementation. And the second part is, Lordship, the result of the sample that was taken.
We are more interested in that.
Yeah.
Did you find anything?
Lordship, in case of cauliflower, Lordship, at one point it was found beyond the permissible limit. And the same from the other point, the cauliflower was found within the limit. They have found in that case, and they are will track and track the main wholesaler or the agriculturist, Lordship, to do the necessary steps. Consequential steps. Lordship.
No, this contaminated cauliflower, what do you do with them? We allowed them to enter the market.
No, and they have not allowed them to enter that.
What happened with it?
That Lordship information they couldn't give me. Yesterday there was the meeting, Lordship.
Okay, we'll list it next week. Come with the complete information.
Yes.
The complete information related to the earlier order dated 3/3/2023 be provided to the court on the next date of hearing, list on
30th March.
30 March.
Items
लूज कवर वो बेलेग किया था फाइल पर इट हो गया था ठीक हो बेलेग किया था फाइल पर इट মানে section পঠিয়াব নালাগে এইখিনি আৰু। Who is for the revenue department? How many villages are there in Assam?
Some,
I know you don't have the answer.
lots of.
Ask your authorities, tell us. How many known, recognized and enlisted villages are there in Assam?
A village or lot.
Lot we don't know, it is your term and we don't understand. And there is no meaning under the law of a lot. That is the term used by the department, villages. Because everything goes by the name of the village, nothing goes by the name of the lot. Lot is for appointing Gaumbura. Suppose you appoint one Gaumbura for more than one village, you call it a lot. So we are not concerned with any lot. We want villages. Do you have any record?
My lord, that I have to take instruction, my lord.
No. Does the department have any record or Assam is a land where there is no record
No,
of the
They
village?
might have, my lord, records, lord.
Who is in charge of the revenue department?
Now, my lord,
Topmost official.
now, my lord, the principal secretary.
Ask the principal secretary that we want the information after some time in relation to the next item, I believe.
Lordship.
We are having a detailed hearing.
Over phone, my lord, can I take this
You can
instruction?
take over phone. We only want the information.
Lordship.
And what is the relevance and significance of a numerical number being given either as a suffix or as a prefix to the name of a village? What is the legal implication of that? Does it mean two different villages or it means the same village? Show him page number 23 and page number 16.
খানা লক্ষীপুর আছে হ্যাঁ জিলা গোয়ালপাড়া আছে ছাটু বাড়ি জেলা আছে সব আচ্ছা ডাকঘর বাগালপুর আছে উপরে আচ্ছা এই তিনে তো ঠিক আছে সব ঠিক আছে বর্তমান ঠিক আছে 93 জিলা গোয়ালপাড়া আছে মহকুমা গোয়ালপাড়া আছে থানা গোয়ালপাড়া রাজু সার্কুল বালি জানাই আছে গাঁওর নাম সেম আই বাকি সব সেম আই একটা কোশ্চেন Page 23.
Yes, Madam Bhuya.
Page 22 is serial number of 90.
Slow.
Sorry. Your
It's
Lordship, I
okay.
was studying.
Do you have any information about the outcome of the earlier order we passed?
No,
To what
not yet,
extent?
not
You
yet.
also do some research. You use your sources to find out.
I will try it.
And you also try to survey the markets, whether you feel that contaminated vegetables are still coming in.
Lordship, I don't have any scientific equipment, your Lordship.
You don't need a scientific equipment.
Number থাকে
By noticing the vegetables, you can make out a lot of things.
ইয়াতে ডাইরেক্ট আপনার
Only thing to conclusively arrive at a conclusion, you need scientific equipment. But to have a
এই গাঁও
prima facie view, you don't.
এইটু গাঁও
Use your sources, use your people, whoever are with you, and also see whether these are being implemented or not, and tell us what
Yes, Your
information you have.
Yes, your Lordship.
You are listing on 30. 30 marks.
Oh, blessing, I am so sorry, Lordship.
Doesn't matter.
Lordship. I take instruction.
So if the villages have numbers, then why each and every village of the state does not have a number? At least my village, I know it doesn't have a number. It has only a name. His Lordship is saying that the village Lochi comes from also doesn't have a number. It has only a name. Number, no number.
In our.
Maybe with you also,
Lordship.
personally, I don't know.
Lordship.
If it is so, then why some of the villages are having a numerical number as a prefix, while others don't have? Does it mean they are two different villages or it means the same village? We want that information. And number of villages. Do you have any old records with you in your department? You are the revenue department. You collect revenue. The department collects the land revenue,
Lordship.
I think through the mozadders.
Lordship.
All the mozadders must be having a list of villages within them because you have to collect revenue.
Yeah.
So I don't think it will be a very difficult proposition to provide that information. We also want to know the statistical figure regarding the number of villages as per the revenue collection that existed in the 1960s and what exists as on today. Whether there is a variation or it is same. After 1 hour. Ask the department to work out. They are the custodian of these records. Ask them to find out. Tell the principal secretary that it is required for the court purpose. Time is 11 now.
So I will try my best.
At 12, you come back, please. Tell us whatever information you have.
Lordship. Alright.
Kunkumati Swami.
Timing item 2.3.
Your Lordship, Mr. Dipankar Nath will address your Lordship in this case, maybe possible for a time being, Madam.
That on that para 97,
My Lord, Muslim.
Muslim on the.
My Lord. Compliance.
Items 5, 8, 9, and 12.
Eight is Lordship. And for item number 8, kindly adjourn the matter for today.
Rejected. We'll take
We
it up.
have to file an additional affidavit.
We don't want your assistance.
Kindly adjourn.
Mr. Counsel, we say this is a larger issue. You are deciding something. We don't want your assistance if you are not ready to render your assistance. No adjournment. We can appoint an amicus and your individual facts, we'll see it later on.
My senior also today, KBI is absent today.
Do you understand the meaning adjournment rejected? Please take note of it. Don't try to frustrate these proceedings. Okay? Yes, Mr. Hamad. If you don't want to address, don't address. We don't want you. On your facts of your individual case, we'll hear you later on. But these proceedings won't be adjourned.
But my item is item 9, Madam.
Item 9.
Madam.
Who wants to address? Basically, we are on 2 issues.
Madam.
Although we have clubbed a couple of writ petitions together. One, on facts, we found your matter to be very weak for declaring the person to be a citizen.
Right.
Then we tried to find out what will be the legal implication of this person being declared not to be an Indian citizen? We want to hear you on that. And on this issue, we are ready to hear any learned counsel who would like to address.
My lord, in this issue, my lord, learned additional AG.
So let him come, please.
My lord, I'm sorry, my lord. Yes, please ask for a adjournment for today only, my lord.
Sorry,
Day
reject it.
Day after tomorrow. it will be-
We'll appoint our own amicus. We'll do the research. We don't do it.
He could not come, my lord, due to
It
his.
doesn't matter. If you want, we welcome everyone to address the court. If you do not want to address, you may not address. We'll proceed with the matter. And this, we have put on notice for the last, I think, 2 weeks. And fixed the date about 2 weeks back. And we also spelled out on what issues we are going to hear.
Understood, my lord. Only for today he prayed.
Nothing, sorry, rejected. And we only invited the learned counsel to address the court. It's for you to accept it or you may not accept it also, but we go ahead with the hearing.
My lord, regarding the my lord, rights to be enjoyed by a non-citizen, my lord,
Hmm.
I have, my lord, I have not find a specific judgment, my lord, but one
No.
article is there, my lord,
As there is no judgment, therefore we are trying to hear you,
my lord,
so that a judgment can come in place.
my lord. Lord, I have, my lord, downloaded one article, my lord. If your lordship permits me, my lord, I may be allowed to produce that.
Any material you want to produce, article, books, some prior judgment, some paragraph from some judgments, whatever. The statutory provisions.
This is from, my lord, Indian Legal Solution, my lord, magazine, my lord. The next page, my lord. The rights to be granted to
right.
foreign national and non-citizens, my lord. The next page, my lord.
Madam Ghosh, you can also address on the issue. Although your petition is on a slightly different context, you can also address if you want. Hearing sound constitution DD versus হেৰি কৰা DD versus খনো দিব আৰু বেয়াৰ এখন DD versus আছে নেকি We are going much deeper into many of the issues.
My lord,
Will be going much deeper into many of the issues.
my lord,
Are you fully prepared?
not fully prepared, my lord,
They have to be.
my lord,
Or that's why we invite any learned counsel to address the court.
my lord.
So you can ask your colleagues also if anybody. So we requested Mr. H.R.H. Chaudhary also. I don't know whether.
I have
he's put
informed
on-
him, my lord. If your lordship, my lord, permits me, my lord, and matter may kindly be listed at 2 p.m., my lord.
Not
I
2
think-
p.m. We are continuing for the whole day. You can come at any time you feel like. Anytime the learned senior counsel is ready, he can come and address the court. No difficulty with that. But no adjournment,
My lord, I'm ready.
even for time. We have started the hearing. And we'll wait, give opportunity to everyone.
My lord.
Whoever likes to take the opportunity may take it. If you don't like, we'll pass our order. Mr. Pine, tell it to Mr. Molina also. We started the hearing. We are giving a very, very patient hearing and most broad-based hearing to anybody who likes to address because the issues are serious.
Informed him, but my lord.
Whoever likes to avail the opportunity, you may do so. If you do not like, you don't impose it on anybody.
Let him argue their point, my lord.
Sorry.
Let them argue their point, my lord, if possible. Because Mr. Mozumdar, he, due to his personal difficulty. he
And
could not
mind
come.
you, this one we have put it on notice long time back. And also you do one thing. Today is Tuesday.
Yes, my lord.
Today we'll continue further on Thursday also. Put up a public notice in the newspapers. Anybody, any organization, anybody who likes to come and address their they can come and join. Where is Mr. RKD Chaudhary? We want him also. Because central government is equally important party with this proceeding.
My lord, for the timing, my lord. Your lordship may kindly go through the Foreigners Act 1946.
Sorry.
Your lordship may kindly see Foreigners Act 1946 for the timing. My lord, section 3, my lord.
Yes.
There, my lord, the
article produced by Mr. Hamad. I'm just reading out one line. The Passport Entry into India Act 1920, Foreigners Act 1946 permit the removal or deportation of a person from India without providing any forum or procedure for determination of the question of nationality of the foreigner or giving any statutory right in the process. This is a violation of the principle of natural justice. This is the one line from the article Mr. Hamad has produced.
that is an article, my lord.
Ah.
Obviously,
So he says it violates natural justice and you are referring to that act.
but my lord, and there. What is the law therein? Is that, my lord, that we have
But
to.
Foreigners Act provides for this determination by tribunal. Procedure is there. This article is possibly little not well-researched article.
Yes, the Supreme Court in Sarbananda
Ah,
says, my lord,
lot
the
of
Foreigners
this
Act is a.
Author Amritesh Panda possibly did not, it's more of a superficial article rather than a deep research article it appears.
In this article, my lord, one section is specifically preferred, my lords. In page number 4, my lord, policy suggestions.
Page number 4, which
Four.
section?
Section 3, my lord, subsection 2, clause E of the Foreigners Act 1946. And other provisions which provide powers to the central government to detain any foreigner and compel them to reside at a particular place with no specified limit, requires a system of checks and balance to ensure that the fundamental.
This is the reason why we are venturing into this effort.
My lord.
Because putting somebody in internment or detention is not the end of the matter.
Right.
What will you ultimately do with that man? Therefore, we have started these proceedings.
Wanted me, I think.
Mr. Chaudhary, we put you a notice about 2 weeks back about that we are going.
Actually, it's not informed today. I had no knowledge today. It is there.
No, we have fixed it long time back, this matter.
No, fixed matter.
And also
I have gone to
requested,
the file also, madam, but
Also-
actually, in fact, yesterday, my name is not there, so he couldn't.
your name may not be there.
No, I could not, but because.
Because as we have requested you and you are not
That's
appearing
I-
for
I'm-
anybody of this
I'm
repetition.
obliged to your worship, but
naturally.
only matter today, actually, just now he told me.
So now what are your views? We'll give you more time, no difficulty,
Yes,
but what are your
I feel
views?
my lord, because your worship, because there is no treaty with Bangladesh.
Sorry.
Whole problem is there. There is no agreement, either extradition treaty or other treaty with Bangladesh. These people are claiming that
এইটো চাওঁ, সন্মিলিত সন্মিলিত মহাসভা সুপ্ৰিম কোৰ্ট। Where is Mr. RKD Chaudhary? We will need him for this.
Lordship, I went to call him, but he's in Lexington court number 1. He will come as soon as the matter.
Ask him to come as soon as he is free. I will come over. I will forward the whole to you. Yeah. To the name to. The Supreme Court in Honmilito Muhammad,
Yes.
that 2015 itself, in paragraph 46.3 provided, while taking note of the existing mechanism procedure for deportation, keeping in view the requirements of international protocol, we direct the Union of India to enter into necessary discussion with the government of Bangladesh to streamline the procedure of deportation. So,
That has not taken place.
so did anybody ever approach the court of law that the requirement of 46.3 had been done or it is not done?
To my information, nobody has.
Because lot of petitions, yes, Madam Ghosh, a lot of petitions from your side also,
Hmm.
that continuous deportation is bad. But did any of the petitioners ever made the effort to have para 46.3 implemented?
I don't think, madam. because
You could have filed petitions
I
instead
think
of
not.
crying horse that deportation, this detention is bad. As an alternative remedy, you could have also proposed that kindly comply with para 46.3. Supreme Court has provided it long time back, about 8 years back.
But problem is lies somewhere else, madam. Bangladesh government idea, madam, some political talk was there.
No, we don't know.
No, they said, madam, we don't have anyone in India, madam. We are not ready to take anyone because there is no. And these people are what they are doing, madam. These people are claiming they are Indian citizens. The problem start there, madam. They are claiming that they are Indian citizens.
No,
They are
once
saying that
they,
we have
Mr.
come from Bangladesh,
Mr.
this is our
Jogi, we
Indian citizen.
understand, once they claim Indian citizen and are declared Indian citizen, no difficulty.
No, but they are declared.
What will
foreigners.
happen when they are declared to be
This
non-citizens?
is the problem.
We are exploring that aspect of the matter. These are all utopian concepts.
Right.
Bangladesh says no foreigners, no one even for us. And the people claim we are citizens.
We are citizen of India.
But what happens when there is a judicial pronouncement that they are non-citizen? Then what happens? What do you do with them?
These are-
So
Yes.
once they are non-citizens, definitely the situation will be there, they will not be entitled to all the rights and privileges of a citizen.
Some rights.
So
Some rights.
this is where we are requiring your assistance to the court. Some rights means which of the rights?
Article 19 will come, my lord.
These are
Tw-
broad,
20.
these are broad-based. We want more fragmented, more detailed.
That's,
answer.
that I will address on that point, my lord. I have already, in fact, I have made some notice of today. Unfortunately,
See,
my lord, I was not
There
informed.
are broad-based, you can say very easily.
No,
Article 14, yes.
It
Article
requires-
20,
it
yes.
requires, my lord, it requires
Article
some,
21, yes. 21A, yes. 22 years, 23 years, 24 years, 25 years.
14 also.
Then again, 15 no, 16 no, 19 some no, 29 no, 30 no.
That's all are for citizens.
Huh. These are broad-based answers. We want more specific instances.
All depend, my lord, it all depends on the stand of the government, my lord.
Nothing.
Because these people
Sorry.
have been declared foreigners.
Mr.
How they are
Chaudhary,
to deal with, my lord?
we are not here to hear any political views. We want exactly submissions on the question of law.
That is what I'm saying, my lord. One part is up to the government.
Nothing
Your
is up to
lordship
that.
concern with the,
Mr.
whether, what
Mr.
rights they are having. my
Mr. Chaudhary, nothing is up to the government.
lord. Yes.
When the court will decide a matter, it will be provided, it is for the government to follow it. So these evasive answers are also, we don't want.
No, not question,
Please,
evasive answer, my lord.
uh,
This is the fact, my lord. Because that to deal, one thing is to deal by the judiciary, other thing is political, my lord. It is
Mr.
political.
Chaudhary, please come to terms.
Yes, ma'am. No, evasive, your lordship is saying evasive, but how?
Yes, we
evasive
want you to submit precisely on the questions of law, what are the rights available, what are the rights not
It's too
available?
much.
And
This-
please confine to that.
Exactly, man. This is the,
Please confine to that.
yes, this is the point.
Don't go elsewhere.
It's true, it is
Yes,
too much.
please.
So this is the question, my lord, your lordship is concerned with
Yeah.
about how to deal with those.
How to deal with
foreigners.
them,
That is true, my lord.
because this is a
But the
problem
point
which
which
is
your lordship has, when they wanted my assistance. my lord.
your assistance on. This is a question confronting the court because of the likely judgment in this writ petition.
That's,
We can't just throw this man to nowhere.
but your lordship is referring that Sammilan, the Supreme Court observation, it is true, my lord. To my information, nobody has.
But
actually-
somebody ought to have followed it up,
That's true.
because there are so many stakeholders in these proceedings.
In this proceeding, it is still pending, madam. I think it is coming either next. week or
So
next week.
somebody ought to have taken up these issues.
That can be some, my lord, because.
Instead
stakeholders-
of taking up the issue from the negative point of view, that detention is bad, why don't you take it up from the positive point of view that this is a requirement of the Supreme Court? Please bring it to its logical end.
That can be done. At like we may ask the some stakeholders, my lord, whom we know they're in the party in the case, man. That we can do, my lord. Because I.
So please cooperate with the court precisely on the rights which this category of people are not entitled. Precisely the rights what they are entitled. We'll declare as such.
that can
And they will be subjected to whatever is the determination. Instead of going to the problems, instead of going to the bottlenecks, instead of going into what had happened, what had not happened.
Yes. State where this is.
Yes, I think this is
But, my lord,
for the
that's
interest
true.
of everyone.
Fine, my lord. That is the only thing which can be done. And that, my lord, I think some.
Because many things ought to have been done, not done. Many things ought not to have been done, but
Done.
it was done.
Done.
So no point in pondering over those, what had happened.
Whatever gone, my lord. Done.
And whatever is within the political realm, we leave it to be tackled at the political realm. But this is a requirement to be decided on the basis of the legal rights and constitutional rights,
That is your lordship concern. We are concerned with that.
which the courts will go into.
So in that case, madam, what I mean, I'll talk to some of the stakeholders, which I know, madam, the Supreme Court, the agitating.
And we are giving an open invitation. Anybody can come and address the court.
Madam,
Anybody can come and address the court, no difficulty. But the presentation should be only on the legal
legal
issues.
point.
We will never allow any political agenda, any administrative agenda, or anybody's personal agenda to be
Yes,
projected before the court.
that belongs to the other
Yes.
side. madam.
There you go to the appropriate forum, wherever you have to go. Here only,
Address on that point.
yes, this is the Constitution of India. These are the laws. These are the international laws. These are the entitlements. These are the human rights laws. Within this confinement of these laws, these are the entitlements. These are not the entitlements. That's all.
That's fine, madam. That will.
So when we give an invitation, we open
Only
it to
problem is,
anybody.
madam,
to-
my name may be record so that I can know my.
Definitely.
Problem is there, madam.
Your names
For
will
this
be-
point.
names will be put. And when we give an open
I'm sorry,
invitation.
madam. Actually, it has escaped. I have not seen, neither they have informed me. That's why I could not.
That's
madam.
okay. And when we give an open invitation, it is not to any political element to propagate their political agenda. It is only, even those elements are welcome, but your presentation should be confined to the legal
But I
issues.
understood.
Nothing beyond that.
Two things, madam. One, I'll have to talk to them. If possible, somebody may push there in the Supreme Court who is pending. Another, your lordships at this point.
No, we are deciding
We are-
for our
this-
purpose. We don't know what is going on
So,
in the.
no, that is also your lordship
any
point, and
other
that also will be seen, madam. Something can be done or not. But here we are confined with that for that sometime, madam, any next week or any time.
No, we started the hearing. You can address next week, on the next Thursday. It will be almost a day-to-day
No
hearing now.
problem. First time. No problem. No problem. First time.
And in doing so, we'll take note of all the prior Supreme Court judgments, the observations there, Constitution of India, all the statutory laws, all other laws that are applicable, including the human rights laws.
That's one thing.
And none of the parties should try to overreach. That's something you are not entitled, that give us that also, and other side also, that something entitled, you restrain them from getting those rights. And this is a huge problem, mind
Yes,
you,
sir. So,
and it
so-
will have its own
Something
implication.
it should be certain in this way that legally it should be actually. thought of. Anyway, Madam, Thursday. No problem.
So we'll hear you on Thursday, day after tomorrow.
Yes, madam.
Thursday, we will finish.
All right.
And anybody else is prepared, I'd like to address today. Yes, Mr. Hamad, your article is interesting, but it's not very deep research article.
May I leave, my lord?
Sorry, yes, please, please. So we expect your presentation on Thursday.
Certainly, madam. I'm sorry today because actually I was not informed, madam. I don't know. Today I got.
And
the notice.
anybody else will like to address?
Madam?
Anybody else will like to address? Any other learned senior counsel or some prominent? Means from the side of the proceedings, would
Yeah.
anybody else like to address? Without repetition, of course.
Bijon Das, maybe madam, if possible, BC Das.
Mr. BC Das.
BC
Yes,
Das.
he is also welcome. Please inform him if he, if the learned
I'll
senior counsel
inform.
address.
I'm informed. If he's there, Thursday. I will.
But no other agenda other than the
That I understand. That your lordship may.
confined to the rights
That
under
your
the law.
lordship, we are also clear on that point.
Yes.
No other agenda.
Because agenda will not permit.
That's. So I'll tell Mr. Bijon Das also if he is ready, otherwise
Say,
I'll,
please.
in your lordship behalf, I will tell him.
Yes, Thursday. Tell Mr. Das also on Thursday we'll take it up. Yes, Mr. Hamad, please
Ma'am.
continue.
My lord. No, in this article, my lord, regarding the, my lord, rights of foreign nationals, my lord.
Yes, please.
My lord, regarding the rights to be granted to foreign nationals and or non-citizens, my lord, certain, my lord, suggestions have been given, my lord.
See, one author here and there doesn't govern the procedure of law.
My lord.
An article available over the net. No background of this person who is writing it. No background of the in-depthness of the knowledge of this person. Many people write articles for many purposes. So we straight away can't go that this one Panda, Amrish Panda had suggested this one, so the court will also proceed in that line only. First, as if we go by this article, this article means this particular.
My lord.
It says that some of the provisions of the Constitution are applicable. It says Article 14. Which facets of Article 14 are applicable and which are not? Or the Article 14 as a whole across the board is applicable? Which one?
But that has not been distinguished, my lord.
Nothing. That's why
Yes.
I'm saying it's not a very article going to greater depth. Because Article 14, as of you know, if you go to those AIR commentaries and other books on Article 14 itself comprises of several volumes. So there are thousands of facets of Article 14. Are all the facets of Article 14 applicable, or Some of them are not applicable and some are applicable. Which one?
Should have been my lord, clearly highlighted, my lord. It's not there.
Nothing. So,
I just like to indicate one point. But in the logic possibly may have gone. In the case of Louis D. Red, 1991 3 SCC 554.
1991.
1991 3 SCC 554.
Ah,
Honorable Apex Court has, this is relating to some American foreign nationals. Honorable Court in paragraph 13 has said that the next point to be taken on behalf of the petitioners that the foreigners also enjoy some fundamental rights under the Constitution of India of this country is also not much help to them. The fundamental right of the foreigner is confined to Article 21 for life and liberty and does not include the right to reside and settle in this country as mentioned in Article 19(1)(e), which is applicable only to citizens of this country. 19 is not only, they have only, their right is confined to Article 21 only, no other fundamental rights. This may help us while deciding this issue.
and Mr. Nath and Mr. Hamad. This issue has to be gone much deeper. There are Supreme Court judgments, there are statutory provisions, there are these accords here and there. This is the prominent being there, some accord. What the government had already agreed to provide to this category of people, what the government has not agreed. After examining all these aspects, then this is not a very short hearing that we can conduct and conclude in this way or that
Yes.
way. Broad-based, please make deep research, formulate what your submissions, what you exactly want to say. Tell us, we'll examine it from the judicial point of view.
Yes, yes.
And take note of the judgment of the Supreme Court in Assam, Honmilito Mahanga and others.
Yes, I have no.
It's a judgment by Justice Pali Nariman.
Logic.
He's a authority in legal history. So most of the provisions can be taken his lordship's view on the judicial side. Read the second paragraph, Mr. Nath.
In Assam Sanmilita.
Read the second paragraph. Especially the court.
Logic. It all began when the Burmese ceded Assam to the British on 24 to 1826 as per the Treaty of Yandabo. This being to an end Ahom rule in Assam, which had begun sometimes in the 13th century. The British annexed Assam and placed it as an administrative unit of the Bengal province as early as 1931. C.S. Mulan, the census superintendent, in his census report said, probably the most important event in the province during the last 25 years. And advent
So mind you, last 25 years, and it's a report of 1931.
1931.
So 25 years means from 1906.
6.
Yes, read.
1905, the division of Bengal was there.
Yeah, and
Logic.
now read.
Yes, yes, Madam. an event moreover which seems likely to alter permanently the whole future of Assam and to destroy the whole structure of Assamese culture and civilization has been the invention of a vast herd of land hungry immigrants, mostly Muslims from the district of East Bengal of migration, East Bengal, wheresoever the carcass there, the vultures will gather together. Politics of Migration by Dr. Manju Singh. He has referred to that from that book. Mullah.
So
Lordship.
as the Supreme Court has taken judicial note of these
True, Mullah.
passages, the problems of the illegal migrants, we are now, the issues related to the illegal migrants, we are now looking into. Whether that has to be looked from the same perspective of a foreigner who enters the country in an illegitimate manner, and this category of people, whether it will be, we have to look it from the same perspective or it will be different. Where is Mr. Chaudhary? We would have liked to have him also, because these answers have to be given by the central government more than the state
Yes.
government. Is he ready or is still in some other court?
In fact, Mullah,
But he is still in some other court. Just inquire and come back.
silent.
Just find out whether he is free from court one or not. So
Issue.
first we have to sort out this issue,
True.
whether the regular laws relating to a foreigner who enters the country in an illegitimate means and these category of people, we have to look at them from the same perspective or from a different perspective. If same, why? If no, then also why? And Madam Ghosh, just sometime back you were arguing one matter on the basis of something related to refugees. I think about a year or two back, I remember you were arguing something on,
Yes.
you have produced some international covenants on refugees or something like that, and yeah, you argued some matter somewhere. If I remember rightly.
Regards to Rohingya,
Sorry,
with regards to Rohingya cases,
I don't know which one exactly, I can't remember, but I remember you were referring to the international covenants on refugees. One,
Yes, Universal Declaration of Human Rights সেইটো কৰি পেলাই
So-
ৰোহিংগিয়াৰ হেৰি কৈ আছিলা সেইটো কৈ আছে
what is the difference between a refugee, a foreigner who enters the country by illegitimate means,
yes, Lordship.
or enters by legitimate means but overstays by illegitimate means, and an illegal migrant of this nature? Whether it is one and the same or it is different.
Yeah, refusing is
Lordship, refugees.
If it is one and the same, most of the laws are already settled. You
Yes.
just adopt it. If it is different to what extent, and what will be the difference of the application of law because of this difference? You had to address on that issue.
Like, if I see the Rohingya refugees, they are not claiming citizenship here. They are here only for of the prosecution over there. They have fled away out of fear for life, and they are not claiming their citizen. They, as a refugee, they want to stay here, and even the UNHCR is there. They are
So what are the
providing-
entitlements of a refugee?
Refugees, then in Article 21, right to food, right to health, shelter, everything comes in under Article 21.
Who will give them, who will provide the shelter?
government of
Did,
India.
no. The shelter will be provided by the government of India, or they will self-provide the shelter for themselves?
Like with regard to Rohingyas, there are refugee colonies. So they are residing in Hyderabad, there is one. In Delhi, there is one. In Jammu, there is one.
And how long will these people stay?
Nothing for years together.
Permanently or?
Because
Mhm.
these people.
No, under the law,
Yes,
under the concept of a refugees, these people are likely to stay permanently or? What is the concept of refugee? That's what we are asking, trying to know from you.
I'll address Lordship on that issue.
Because when a non-citizen enters the country illegitimately or enters legitimately and then overstays illegitimately, possibly the intention is to stay as long as possible, and which may not be short of staying permanently. What about the refugees? Because they come because of a different background. They are persecuted, they are having difficulties in staying in their own land. So they cross the international border, enters another country for the immediate succor and immediate relief from the events that are taking place in their own land. So are these people related to the likelihood of how long those events in their own land will continue? So you look at the concept of permanency from that point of view. Or once you are decide you are here forever, which one?
I'll address Lordship to
Mhm.
do some research work, Lordship.
When you are refugee, mind you,
Yes, Lordship.
when you are illegitimately entering person, and whether these are the third category of people or they are also belong to those earlier two category.
The refugees cannot be placed at the same place with the foreigners, as we are.
No, we
there is
want
lot
a detailed submissions on this.
True, Malak. Because obviously, Malak, from the word refusing, Malak, they are on their own, Malak, they are praying for shelter. Because of some problem at their
Some persecution taking place in their place of origin,
That
which
is-
makes it unlivable for them to continue in that manner. No other way out, they just cross the international border, enters another country. In that country, they are called the refugees.
refugees.
And there is a law of refugees to what should be provided to them and what should not be provided to them. But we want to know whether they are permanently in the other country or they are till the persecution continues in the place of origin. Because the reason is persecution.
Yes, Lordship.
So do these category of people continue to have the right of a refugees in the other land if the persecution stops or comes to an end? Or at some point of time you forget about your past, now we are here,
We are
give us
here.
everything.
Like directly also, India is not a signatory to the international treaty.
But India
on
is
the Universal Declaration of Human
but
Rights.
India is a country with a wide heart, still they're accommodating them. Big heart, I mean. So there is treaty or no treaty, the people are being accommodated. So why do you refer to a treaty now? Then India could have very first day send them back straight away.
And that is Lordship.
Means don't blame the country in any manner. So today what we do? We have to carry forward further.
I'll take more preparation, my lord, in this regard, if your lordship permits me, my lord. On Thursday, possibly, my lord,
Lordship,
I'll
on the,
try to satisfy your lordship, my lord.
on the issues today, Lordship has,
Yeah,
today Lordship has
Constitution
indicated.
Constitution comes now.
Constitution.
Constitution, we are at. Hmm.
একেবারে বৃহস্পতিবারে কোনো problem না।
Yes, Mr. Chaudhary.
Brother. What you say? Foreigners, what if they are right? Remember the kind of facility they have, you didn't feel like they are-
Mr. Chaudhary. To give a more meaningful direction to the proceedings,
Lordship,
to begin it, we would like to know whether a refugee, a foreigner who enters the country in an illegitimate manner or enters in a legitimate manner but stays back in an illegitimate manner, and illegal migrants with whom we are concerned, they belong to the same category or they belong to different categories, different classifications?
Lordship,
And if yes, most of the laws of refugee and foreigners are settled to a great extent. If different, whether those laws as a whole will be applicable or some of them will not be applicable, or there must be some more provisions in respect of this category of people.
there are.
First, tell us whether they are same or not. And begin with that paragraph. Where is Mr. Nathkon? I had given my copy. Read that para 2 of the judgment of the Supreme Court. Read the para 2. Don't have to read it.
The report of the superintendent census.
No. What you're reading? Read the paragraph 2.
Okay.
Hmm. In the context of that's judicially taken note of by the Supreme Court. So in this context, we are putting this question. Whether they all belong to the same category or these categories will be little different, and the point of view from where we'll have to look at their rights and entitlements will also be different.
Lordship,
You
You-
prepare yourself, just don't. We'll continue on Thursday. We
Yes.
want your full participation
Yes.
in these proceedings. Because the view of the central government will be very important,
yes.
most relevant.
I'm sorry, Lordship, something was going on in Kotha.
I know, doesn't matter. That will be every day. But you find out some time
Yes,
for this
yes,
proceeding.
sure.
okay.
I'll do that, Lordship.
Especially you read the judgment from the beginning, there are some directions are already given by the Supreme Court. Some implications are also stated. And if that is so, whether this category of people are to be put in the same bracket as that of a refugee or a person, or they have to put in a different bracket. If different, then you explore what are the rights they retain and what are the rights they are not entitled.
Lordship.
And we also want your information. Please read paragraph 46.2 or something of that one. Where is the copy go? This one we'd like to have your response, 46.3. Taking note of the existing mechanism procedure for deportation, we direct the Union of India to enter into necessary discussion with the government of Bangladesh to streamline the procedure of deportation. This is the judgment of 2015. So now 2023. What happened pursuant to that direction? The detailed up-to-date information.
Yes, yes, I will get that, but the other country won't accept.
Sorry,
The other country won't accept. That, but what action has been taken on this? Definitely. Lordship.
suppose they don't accept. And this
Then-
category of people are declared here.
What happens?
What happens to
That
them
is-
now? You cannot forget that they are human beings.
Yes.
Then what do you do with them?
That is something to.
Think about, tell us.
Lordship.
It's a serious issue. It's not
Yes,
just,
It should have been decided long back, like things,
but we are compelled, we are bound because there are
yes,
this is a proceeding before this court. In all likelihood, we'll have to declare this person to be a non-citizen.
why not?
Because no materials could be produced to. Even in the writ court, we gave the opportunity to produce any material. The person is unable to produce. So ultimate conclusion will be that this person will be declared to be a non-citizen. Only declaring is not good enough. What will you do with this person now? We have to provide for something.
Yes.
And that is precisely we intend to do. So on Thursday,
Yes.
we start the full hearing on Thursday. No more adjournments. Please don't seek any more adjournment. And if anybody is not interested, you may not address the court. And whosoever is interested may please come forward. Yes, Mr. Hendrik, we wanted the information from you. How many number of villages exist in Assam?
Lordship, my lord, there's our telephonic instruction, my lord, I have received. There are, my lord, the 18,563 total revenue villages.
10,000,
No, 18,563, lord.
18. Can we have the complete list of those villages?
Lordship, my lord.
Not today, tomorrow, day after tomorrow.
And my lord, the number, lordship was asked, my lord, that
As on a 1960s or 1950s, how many villages existed?
my lord, that had to, my lord, take, my lord, sometime, my lord, to take the instruction. My lord, that I have been taken, my lord, only that.
Mr. Nath, you also maybe need the help of some other department also. The number of villages that existed in the 1950s and 1960s, or take up any cutoff point, and the number of revenue villages that exist as on today. And the complete list of villages of the two periods.
And lordship also asked me the number, the numerical number. This is the my lord, map number. They told me that I have, my lord, that talk with the my lord, ADC.
Mr. Hendrik, we understand that. Then why doesn't every village have a map number?
My lord, that
Why
my
some
lord,
villages
only
have a map
Gwalpara-
number and why some villages don't have a map number?
The Gwalpara district, they have the map number. That's why they have given my lord.
So it is
number.
district wise.
District wise.
So does the department intend to say that every village in Gwalpara has a number?
My lord, that.
There is no village without a number in Gwalpara.
My lord, that map number only, my lord, that they have maintained, my lord, the Gwalpara district. As far as my other district, I, my
No,
lord.
no,
I
please
did not
apply, ask the department to apply the mind and give the reply. If, are we to accept the statement that in the district of Gwalpara, every village has a map number as a prefix to the name of the village? Is it right? Can the department make that statement?
That, my lord.
So ask the department official not to come with these half-baked answers. We want complete answers based on their records.
Lordship may run some time much.
Means, in other words, ask the departmental official to avoid the habit of just providing an answer to the court. Court will give a question, we'll give an answer. We are not on that. We want the correct information, correct and complete information. There's a reason why you're putting this question to you. Today, in that other matter, we came across one number 309 Abrar Bhita
Lordship.
village. That is within the Lakhimpur police station. Another 101 Abrar Bhita, that is within the Gwalpara police station. So what is the relevance of this number 309 and 101?
My lord, that information I have taken this one, my lord, that 305 numerical number from the Gwalpara district. My lord, they.
So they are two different villages, that means, or same
No,
village?
no, lordship, my lord, in the 1966, lordship, it was the 305. After my lord, settlement operation, my lord, when the my lord.
Mr. Henry, does the department need to say that there was reorganization of police stations also in the Gwalpara district?
My lord, that after my lord, that they have been, my lord.
We understand your reply. Does it mean that there was reorganization of the territorial jurisdictions of the police stations?
That means,
Then how can the same village be under two different police stations in 2 different years then? That's why I'm telling you, don't please ask your departmental official not to give these half-baked answers. Just to get over for the day, a question is put, let us give an answer. It's over for us. No, we don't want that approach. Because that is having a very serious implication in that matter. If this is the same village, some legal right flows in favor of that person. If it is not the same village, it does not flow. And your authorities are now trying to give answers which is neither here nor there. Please come back with Or ask one responsible officer from the revenue department to remain present with complete records. So that we can avoid the habit of giving answers to pass over for the day. Okay. Who can remain present? Who has the good knowledge of this revenue matters? Which official? Which official of the revenue department has a good knowledge of the records pertaining to the revenue department? Yes. And another matter, we asked the revenue department to file an affidavit. I think which matter it was? It's listed to file an affidavit on the non-cadastral village. It is interesting. কোনটা লিখে আছে 47 এটা পড়ি লিস্ট করাই দিন এটা লাগে না আজি অর্ডারটা দিয়ে দিও
Let me take over telephonic instruction, who will be, who have
Yes,
done knowledge.
we don't pass any order. You just ask the departmental official to remain present so that he can give the answers
Lordship,
more easily.
Lordship was given order, my lord, that,
Why do we need an order?
otherwise, my lord, that
He won't come.
he will come, my lord, even then, my lord, that he might have some other works also. Security purpose.
The matter is heard in part, list next Thursday for further hearing. In response to a query raised by the court, Mr. J. Handick, Learned Counsel for the Revenue Department, has stated that presently there are approximately
18,563.
18,563 number of revenue villages in the state of Assam.
But there are, my lord, that 1060 non-cadastral village. My lord, it, my lord, that village,
Which also includes,
my lord, it was not included, my lord, as because we are not taking any revenue from this.
it stated that over and above, there are 1,060 number of non-cadastral villages, meaning thereby where no cadastral survey had in, meaning thereby villages where no cadastral survey had been made. You'd request the presence of a official of the revenue department on the next date of hearing in the court to provide the answers relating to the related to matters from the records maintained by the revenue department. You choose who will remain, whosoever is most convenient according to you. The revenue department to also provide the information to the court as to what was the number of revenue villages that existed during the period, during the decade 1960. As per the revenue records. The revenue department to also provide the court with the names, with the list of containing the names of the revenue villages as on today, as well as the names of the revenue villages as it existed during the 1960s. In course of the hearing of the proceedings, Mr. Jed Hamad, land counsel for the writ petitioner in WPC
7632
7632
of 2022.
2022 has produced a write-up on the topic analyzing the rights of foreigners under the Constitution of India. Full stop. Which articles, although not a deeply researched article, contains certain provisions which, according to the author of the article, are the rights, fundamental rights that are available to a foreigner, and the rights and fundamental rights which are otherwise not available to a foreigner. Further discussion shall follow. Mr. Jed Hamad prays for an adjournment to make a more detailed examination on this said aspect. Mr. H.R.A. Chaudhary, learned senior counsel, who had been requested by an earlier order to appear on behalf of the persons who are generally the proceedings in these proceedings before the Foreigners Tribunal, also seeks for an adjournment to further examine the matter. Full stop. নামটো দি দিব next order নিদিও HRHR নামটো দেখাই দিব both Mr. R.K.D. Chaudhary, learned DYSGI, and Mr. D. Nath, learned Senegal for the central government, and Mr. D. Nath, learned Senegal for the state of Assam, government of Assam, are also present in the hearing, and to give direction to the proceedings shall make their submissions as to whether the category of persons who are declared illegal migrants can be categorized or classified to be seen as that of foreigners who enter the country illegitimately, as well as the persons who enter the country as refugees. And if there is a difference, what would be the substantial difference which would require a different direction to be given to examine the rights and privileges of such category of person? Any other learned counsel or responsible person or organization, if want to address the court on the said issue, may do so by indicating their presence to the court master on the next date of hearing. But however, the presentation should be confined to the legal issues involved and not for any other agenda that any such other person may have, person or institution may have.
So, may I have the copy of this order?
A copy of the order to Mr. J.
To communicate.
Mr. Handy, you remain present on Thursday also. We'll need your presence. Thursday. আৰু এটা আছে যে সেইটো শুনো। This item 2 and 3 also will hear on Thursday along with this series, or you want to do a separate hearing for that? I think 2 and 3 can be heard separately. I think we'll come back here. 2 and 3 will hear you. Oh. And Madam Ghosh, what about your matter? Oh.
Worship, I am for item number 8.
My lord, that day this matter was supposed to be disposed of.
But we, for some reason, we have put up for further hearing.
Yes, lordship.
Yes. That one we can segregate from this series,
Yeah,
or we
yes.
can hear it together.
Because this, she has certain documents which was not proved. And.
No, we are not on documents, etc.
and-
We are basically on the
that
procedure
I-
that has to be adopted.
Yes, Lordship. If if this may be segregated,
Yes, Mr. Pine, this hearing, we can do it today itself, I think.
Vignesh is to dispose of.
And here also, Mr. Chaudhary and Mr. Nath, if you are free, we'd like to hear you also on this issue.
Let this matter be also heard together, my lord,
Together with which one?
along with this, my lord, item 8, 9, and 10.
Why?
My lord, the issues will.
Nothing. It is not at all connected. Only thing it is listed on the same day. That is the only connection we see.
Then it may be segregated. my lord, no problem.
Here we are deciding what procedure the tribunal has to adopt. What are the responsibilities and duties of the state government in these proceedings? And that is, and the other one is on the rights and privileges of a non-citizen. They are totally different issues.
Yes.
For the other matter, we stay back, please. Mr. Chaudhary, you're having some other matter somewhere? Can you stay back or?
I'll come back. Lordship.
Hmm? No, we want to hear you on one or two aspects on this matter. On this matter.
I'll be.
Okay, we'll come back and hear it.
Item 5.
यार था order list में दिया हुआ। Where is Mr. Nath gone? And also Mr. Chaudhary, if possible. Mr. Nath, we'll like to have your views. Also, because Mr. Payeng is only for the tribunals and he also represents the Home Department. But we want to like to have the views of the government of Assam as a whole, not just confined to the Home Department or the tribunal. These proceedings are quite different from the regular proceedings. I think you agree with it. Means their purpose, nature, everything is different. And most relevant is Section 9 of the Foreigners Act. What does it provide?
Burden of proof.
Hmm.
Section 9 provides burden of proof.
Yes. So, In any case, not falling under section 8. Section 8 is
Section 8 is determination of.
when a foreigner is recognized as a national by law of more than one foreign country, or where for any reason it is uncertain what nationality, if any, is to be ascribed to a foreigner, that foreigner may be treated as a national of the country with which he appears to be, to the prescribed authority, to be the most closely connected. So this is a totally different circumstance. In cases not falling under section 8, means anything else other than that, including these proceedings. Any question arises with reference to this act or any order made or direction given thereunder, whether any person is or is not a foreigner, or is or not a foreigner of a particular class or description. So we are mainly concerned with a is or is not a foreigner of a particular class or description. Not perhaps not the regular foreigner also. The onus of proving such person is not a foreigner or is or not is not a foreigner or is not a foreigner of such particular class or description shall notwithstanding. So it's notwithstanding. It starts with a notwithstanding clause. Anything contained in the Indian Evidence Act.
Lies upon those.
So all that it says is that the onus of proving that such person is not a foreigner or not a foreigner shall, notwithstanding contained in foreigners, is lie upon such person. So here the burden of proof,
Is on the
contrary to the provisions of the Evidence Act, is shifted to the person. Otherwise, it's always a state versus that proceeding. So the onus ought to have been on the state to prove that he is a foreigner. Now the law reverses that requirement, and it is the proceeding now to show that he is not a foreigner. Evidence Act comes out. You want the Evidence Act?
Yes.
Video was here. Burden of proof. Various section. Burden of 100. Section 101.
Yes, 100.
Section 101 is
Burden of proof.
Mr. Chaudhary will like to hear you also on this issue. Because it's a central law we are required to interpret, so we definitely need your views. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. So this is the burden of proof. 101 is now, by virtue of section 9 of the Foreigners Act, is on the proceeding.
On the person.
So what he has to prove? The existence of the fact. What existence of the fact? That he is a
Indian national.
Indian citizen, or that he is not a foreigner.
Gotcha.
So once the person discharges this burden by producing any material he would like to produce, more often than not, what they produce is either a voters list prior to 1971 containing the name of some person, or they will produce a document which existed prior to 1971, like those relief eligibility certificates or some land purchase document or any kind of document that they can think would be the appropriate. which shall contain the name of a particular person. Then the proceeding states that either that person he himself, he or she himself, or the person is the father, or the person is the grandfather, whichever may be according to the facts of the given case. Suppose he takes the stand that the man there is his father. He will have to prove to another set of material or document that that person whose name appears is his father and none else. Of course, along with it, qualified by and none else. More often than not, we have cases having similar name. Suppose the name of the person is AB. AB's name appears in that voter list. My father's name is also AB, so it is that AB. Normally, that's a stand taken. So you have to also prove that that AB and this AB, they are one and the same person. This is what we use. Once this burden is discharged, whether convincingly or unconvincingly, what is the next step for the tribunal to do? And mind you, in their anxiety, these people, what they do, they produce more than one material, thinking that if X clicks, it is well and good. If X does not click, rely on Y. If Y also does not click, rely on Z. Ultimately, a huge number of materials are produced before the tribunal. In this circumstance, what is the tribunal required to do? Shifting the burden of the people. Initially. So now also take note of section 102 Evidence Act. The burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Again, it is this one.
Gotcha.
So now what is the tribunal supposed to do now?
But not- in fact, Mullah, this as regard this burden of proof, section 9. This is the burden of proof. This is
Just a minute.
burden of proof, Mullah, this particular portion. It has been widely discussed in the case of Sarvananda Sonowal, Mullah. Para 21 or আরম্ভ করবো। 26.
Yes, Mr. Nath.
But this burden of proof as provided in under section 9, this has been
Is on the proceeding.
this has been discussed in detail in the Sarvananda Sonowal 1. Sarvananda Sonowal's case, Mullah. So, Lordship, Sarvananda Sonowal is 2005, 5 SCC 665.
1, 2.
1, Mullah.
Which paragraph?
Paragraph 21 to 26.
21 to 26.
21 to 26.
The Justice G.P. Mathur's judgment.
Lordship. Yes. Lordship.
21 to 26.
Paragraph 21 onwards, may I read?
Yes.
The legislature then enacted the Foreigners Act 1946, which repealed the 1940 Act. Section 2A of the Act defines a foreigner, and it means a person who is not a citizen of India. Subsection 1 of Section 3 lays down that the central government may by order make provision either generally or with respect to all foreigners, or with respect to any particular foreigner, or any prescribed class or description of foreigner for prohibiting, regulating, or restricting the entry of the foreigners into India, or their departure therefrom, or their presence or continued presence therein, without prejudice to the generality of the power conferred by subsection 1. Subsection 2 confers power to make wide-ranging orders concerning a foreigner which have been enumerated in clause A to clause G, which includes that a foreigner shall not remain in India or in any prescribed area therein, or if he has been required by an order under this section not to remain in India, meet from any resources at his disposal the cost of his removal from India, or remain in such area as may be prescribed, and shall comply with such condition as may be specified, or shall be arrested or detained or confined. Subsection 3 provides that an authority prescribed in this behalf may, with respect to any particular foreigner, make order under clause C or clause F of subsection 2. Section 4 confers power for directing a foreigner to be detained or confined in such place or and manner as the central government by order determine. Section 4(3) directs that no person shall knowingly assist an internee to escape from custody or harbor an escaped internee, or to give any assistance to such foreigner. Section 5 places restriction upon a foreigner to change his name while in India. Section 6 casts an obligation on master of any vessel or pilot of any aircraft landing or embarking at any place in India to give particulars with respect to any passenger or members of any crew who are foreigners. Section 7 casts a similar obligation on hotel keeper in respect of foreigners accommodated therein. Section 12 confers power upon the authority who has been conferred power to make or give any direction under the Act to further delegate any of the subordinate authority to exercise such power on its behalf. Section 14 has been amended by Act 16 of 2004, and now maximum punishment under the said Act is 5 years and also fine. Section 14A and 14B, which have been added by the opposite amendment, provide for punishment with imprisonment for a term which shall not be less than 2 years, but may extend to 8 years. Section 14C provides for some punishment for abatement of offense under Section 14A or 14B. Section 9 of this Act is an important, and it reads as under 9, burden of proof. If in any case not falling under Section 8, any question arises with reference to this Act or any other order made or discretion given thereunder, whether any person is or not a foreigner, or is not a foreigner of a particular class or description, the onus of providing that such person is not a foreigner or is not a foreigner of such particular class or description, as the case may be, shall, notwithstanding anything contained in the Indian Evidence Act, lies upon such person. This Act confers wide-ranging power to deal with all foreigners or with respect to any particular foreigner of any prescribed class of description of foreigner for prohibiting, regulating, or restricting their or his entry into India, or their presence or continued presence, including their arrest, detention, and confinement. The most important provision is Section 9, which casts the burden of proving that a person is not a foreigner or is not a foreigner of such particular class or description, as the case may be, shall lie upon the person. Therefore, where an order made under the Foreigners Act is challenged and the question arises whether the person against whom the order has been made is a foreigner or not, the burden of proving that he is not a foreigner is upon such a person. In Union of India versus Ghus Mohammed, the Chief Commissioner of Delhi served an order on Ghus Mohammed to leave India within 3 days, as he was a Pakistani national. He challenged the order before the High Court, which set aside the order by observing that there must be a prima facie material on the basis of which the authority can proceed to pass an order under Section 3(2)(c) of the Foreigners Act 1946. In appeal, the Constitution Bench reversed the judgment of the High Court, holding that onus of showing that he is not a foreigner was upon the respondent. The central government has made a Foreigners Tribunal Order 1964 in exercise of power conferred by Section 3 of the Foreigners Act. Clause 2(1) of this order provides that the central government may, by order, refer the question as to whether a person is or is not a foreigner within the meaning of the Foreigners Act 1946 to a tribunal to be constituted for the purpose for its opinion. Clause 3(1) provides that the tribunal shall serve on the person to whom the question relates a copy of the main grounds on which he is alleged to be a foreigner and give him a reasonable opportunity of making a representation and producing evidence in support of his case, and after considering such evidence as may be produced and after hearing such person as may deserve to be heard, the tribunal shall submit its opinion to the officer or authority specified in this behalf in the order of reference. Clause 3(a)(1) provides 1(a) provides that the tribunal shall, before giving its opinion on the question referred to in subpara 1(a) of para 2, give the person in respect of whom the opinion is sought a reasonable opportunity to represent his case. Clause 4 provides that the tribunal shall have the power of a civil court while trying a suit under the Code of Civil Procedure in respect of summoning and enforcing the attendance of any person and examining him on oath, requiring the discovery and production of any document and issuing commission for the examination of any witness. It needs to be emphasized that the general rule in a leading democracies of the world is that where a person claims to be a citizen of a particular country, the burden is upon him to prove that he is a citizen of that country. In United Kingdom, the relevant provision is contained in the Immigration Act 1971 and subsection 1, 8, and 9 of section 3 thereof reads as under. 3. General provision for regulation and control. 1. Except as otherwise provided by or under this act, where a person is not a British citizen, A, he shall not enter the United Kingdom unless given leave to do so in accordance with the provisions of or made under this act. B, he may be given leave to enter the United Kingdom or when already there, leave to remain in the United Kingdom either for a limited or for an indefinite period. C, if he is given a limited leave to enter or remain in the United Kingdom, it may be given subject to conditions restricting his employment or occupation in the United Kingdom or requiring him to register with the police or both. 8. When any question arises under this act, whether or not a person is a British citizen or is entitled to any exemption under this act, it shall lie on the person asserting it to prove that he is. 9. A person seeking to enter the United Kingdom and claiming to have the right of abode, there shall prove that he has the right by means of either a United Kingdom passport describing him as a British citizen of the United Kingdom and colonies having the right to abode in the United Kingdom, or a certificate of entitlement. Next paragraph, somewhat similar provision is contained in the Immigration and Nationality Act of USA, and section 291 places the burden of proof upon the person concerned in any removal proceeding. Section 318 provides that no person shall be naturalized unless he has been lawfully admitted to the United States for permanent residence in accordance with all applicable provisions of the act, and the burden of proof shall be upon such person to show that he entered the United States lawfully. The Immigration and Refugee Protection Act 2001 of Canada contains a provision of placing the burden of proof the person concerned to establish his right to have a permanent residence in the said country. Section 188 of the Migration Act 1958 of Australia provides that an officer may require a person whom the officer knows or suspects is a non-citizen to A, show the officer evidence of being a lawful non-citizen, and B, to show the officer evidence of the person's identity. There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship, normally he may require to give evidence of his date of birth, place of birth, name of his parents, their place of birth and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A 1D of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on these points, the state authorities can verify the facts and can then lead evidence in rebuttal, if necessary. if the state authorities dispute the claim of citizenship of a person and asserts that he is a foreigner, it will not
95.
only be difficult but almost impossible for them to first lead evidence on the associate point. This is in accordance with the underlying policy of section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving the fact is upon him.
Mm.
So this is the reason, my lord, why the burden has been put to the proceeding, Lord, as per section 9.
আমার answer to Yes, Mr. Nath.
Para 27, 28, my lord, some case laws are discussed, my lord. Kindly come to para 32, my lord.
Mr. Nath,
Logic.
Lordship has pointed out,
Logic.
read the last 3 lines of para 26 of page 695.
Logic. Last line.
Last 3 lines.
If
I
the-
think that is the answer, what we are
Yes,
asking you.
yes, Lord. Yes, Lord. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence
Now, after he has given evidence on the points,
on the points.
the proceeding in discharge of section 9 burden of proof has given evidence on these points.
Logic.
The state authorities can verify the facts and can then lead evidence in rebuttal.
In rebuttal.
This is what we are trying to ask from
Logic.
you. Now, what is the procedure adopted? Are you aware? We can confer with Mr. Paying. Now, all that the tribunal does, from our experience of the hundreds of such matters we have dealt till now, all that the tribunal does is, tribunal will gather all the materials they have produced. Say X, Y, Z 3 materials are produced. They'll take before them all the 3 materials. Then the tribunal will have to find out, the most common word is discrepancy. What is the inconsistency between X and Y? And what further is inconsistency with Z? They'll line up all the so-called discrepancies. If nothing happens, they use the word disbelievable. The evidence is given, tribunal finds between the 3 materials produced, these are the inconsistencies. So entire evidence is disbelievable, discarded, declare this man to be a foreigner. He could not discharge.
He failed to discharge the burden.
Is it the correct approach? This is what, in fact, in this judgment, we also want to lay down what the tribunal is required to do also. Let us pass a more comprehensive judgment on the entire thing.
My lord, now the tribunal following.
Let Mr. Nath complete.
Yes.
So what do you want to say?
No, as your lordship asked, what tribunal is doing now?
Tribunal is doing that only.
Let-
Tribunal, you can take out samples of all the judgments are there before us in the 15 matters that are listed today. See for yourself. You can be almost sure that in all the cases, tribunal has done that. So now the question we are like to put across the state is, once the initial burden is discharged, instead of venturing into the theory of discrepancy and the theory of disbelievable, the law of non-traversal will be applicable. Because the state is not controverting that evidence in any manner.
In fact, one of the discrepancies are pointed out while cross-examining the witness possibly.
Nothing is pointed out. Cross-examination is almost next to nil. And you can refer to a few of the judgments we rendered in course of the last week. in wherever the state tried to cross-examine, they have in fact helped the proceedee to establish case, which in his examination in chief he could not, whatever record was there, even that was made up in cross-examination. I think Mr. Ali was there. If you want, we can give it a case number also. You can see it for yourself. Mr. Nath, you would like to say about something?
Mr. Payeng,
My lord.
can you give us one instance where the prosecution side has given the rebuttal evidence?
My lord, that's
For
why-
last 2 months, so we have never come across any such instances.
my lord, that's why there generally there is no rebuttal evidence as such, my lord. The state has not given any evidence.
This
I-
is
I
the,
have- I have
Mr.
noticed, my
Payeng,
lord.
this is the reason we have
I understood, my lord.
taken up this issue.
My lord, because.
And Mr. Payeng, howsoever earnestly you may try to defend yourself, the theory of discrepancy and disbelievable is a very, very weak concept in principle.
Yes, obviously. my
In
lord.
one odd matter, you may succeed because it is not that the concept of disbelievability of an evidence is absolutely not tenable. It is
That's-
there, no doubt,
This
but
will-
in a very, very circumscribed manner. Suppose there are corroborating evidence to show that the witness was not present in that particular place. And the witness comes before the court and states of existence of a particular fact. That evidence may be disbelieved by the court, not because seeing the face of the witness or seeing the nature of the witness, but because it is corroborated by some other evidence on record, which shows that this man could not have, he could not have known about this fact, existence of this fact. That is the reason. Not by using the theory of this, what you call? Disbelievable and discrepancy. That because the material X produced says a little bit in this much and the material Y says a little bit of contrary to that, not wholly contrary also, just a small contradiction. Either as per the first material age ought to have been 50 years, as per the second age is 45 years. Otherwise, it is corroborating with each other. So these are the things we are trying to ask you. Where is the role of the state in these proceedings, where after the proceedee has given his evidence on his points, the state can verify the fact and then can lead evidence, which is in fact what the Supreme Court has also provided, and specifically for the proceedings of this nature, not even that it's a general law, specific for this.
My lord, this issue has come again and again earlier also, my lord. Why, my
But
lord,
again and again, there is a failure on the part of the state. That is the difficulty.
my lord, the evidence of giving rebuttal evidence, my lord, will come when, my lord, if my
So,
lord,
Mr.
evidence-
Payeng, you are trying to justify your tribunals.
My lord,
No,
this
in
is-
other words, we find Mr. Payeng always trying to justify this absurd method we adopted.
no, my lord, this is a.
Then we would, very well, you can do it. Then you'll be compelled the court to allow each and every writ petition from tomorrow. You're free to do so.
I'm, my lord. but that is the-
Matter which logically, reasonably, and with materials, we are trying to point out that it is not consistent with the requirements of law. And if you're trying to justify it, we accept your submission, Mr. Payeng. But mind you, the outcome of that will be every proceeding would have to be allowed from tomorrow.
My lord,
Everyone.
I'm relying on judgment of this honorable court, my lord. Here it is.
We are on the Supreme Court and you are on this court.
Yes, my lord, that.
Don't rely on those judgments, because none of the judgments had gone into this question. It may be a stray observation here and there, which obviously not a ratio. So let Mr. Nath address. Yes, Mr. Nath, you are on something. Do you feel the state will ever succeed in this method? When there is a requirement of law to verify the facts and lead evidence in rebuttal.
In rebuttal.
And invariably, this is not followed. Is this the mandate of the state government that don't do it?
No, Malad, wherever rebuttal evidence is necessary, Malad, the state has to give. Malad.
First, tell us one aspect.
Logic.
The proceeding relies on a voters list, say of 1966, indicates one person there. Let that person be X, that he is my father. Okay. That voters list will show the age of the man to be, say, 50 years. He refers to a later voters list, say of 1977. If he is 50, his age ought to have been 62. But for some reason, the age is written, say, as 58. Or as, say, 65. The state and the tribunal will take a stand that this is a discrepancy.
Some doubt arose.
When it is the admitted position of the Election Commission that age is not written correctly in any of the voters list. It is only an indicative. Plus, I think there is a judgment, will refer it to you, of the Supreme Court, I think, that age in a voters list is not relevant. In the background of this law, you are trying to find out discrepancy on the basis of a provision which is not relevant. Supreme Court had declared it is not relevant.
Then, Malad,
And then develop the theory of discrepancy. So therefore, what you do, you reject both the lists.
if the Supreme Court has already clarified.
You reject both the list and then say that the proceeding has failed to discharge the burden. This is the approach in and out invariably in almost all the proceedings. This is our experience of reading.
In that case, Malad,
We have read hundreds of judgments of the tribunal till now. Nowhere we have found any deviation from this concept. Then, in one voters list, suppose the man would be, his name will be written as Sokumuddin. In the next one, instead of K, it will be written as Sofumuddin, F. Discrepancy. Why? Because one is Sokumuddin, other one is Sofumuddin. This is the general trend we are getting. Rejected. Is the tribunal doing their duty entrusted on them by the law? Duty entrusted is to render an opinion whether the man is a citizen or he's not a citizen.
on the basis of the documents given by him,
Yes.
evidence on.
Instead of doing that, the state will quietly sit there. As his lordship is pointed out, except for one or two cases, we have not seen any cross-examination of any witnesses.
No, there has to be.
Why? Somebody gave the idea to the government council appearing for the state that section 9 says burden is on the proceeding. You just keep quiet, don't open your mouth there.
No.
Whatever material is projected, just raise some absurd issues, discrepancy, unbelievable. Please go.
No, when an evidence is adduced before a court,
Whereas the Supreme Court has provided in the same para 26 that the state authorities can verify the facts, because these are facts in most of the cases, other than a few oral evidences, are made on the basis of public records. Okay. Public records in the form of voters list, public records in the form of those eligibility certificates, public records in the form of ration cards, etc., all the public records. Then next category comes is the certificates issued by those Ganguras and those secretaries. Those are again your own people.
but in respect
You
of-
can also go and get it verified from the Gangura that why did you certify this man like this? Do you have any basis? Nothing is done. You have an organization called Superintendent of Police Border and his office for the entire district. only function they have done till now, what we have found is make a reference. If a superintendent makes 10 references in a given month, that is the only work he does. Nothing beyond that. And this is we are speaking from facts available from the records of these proceedings. Not a single word is beyond the records. He does have no other work in this world. Suppose the proceeding refers to one voters list of 1966 containing the name of X and claims that this X is my father. Why can't the police authorities, you have a separate border police department in every district. You don't have to bother the regular police also. Why can't you go and make an inquiry in that village? Find out who that X is. Of that say 66 voters list of village A, whosoever is referred as the father, why can't the superintendent of police bother through his entire personnel at his disposal, not go to that village, make an inquiry that somebody is making a claim that X is his father of this village, of this voters list. Where is X? You can inquire from X that is he your son? Many cases you will find X will give us, and no, he is not my fine. My son are so and so, they are still in this village with me. This must be some stranger. If you have this material, can't you come back to the tribunal through your government leader, put this material before the court? What prevents you from doing it? Will the decisions be not more foolproof? Then just invariably going into this concept of this discrepancy and unbelievable. Just put it across. Yes, we have verified from this X, and suppose it is right that yes, X is his father, that man exists in that village, or he existed earlier, now his other sons are there, make an inquiry. Be fair to this proceeding. Allow him to have his citizenship. But there is more possibility of detecting the correct state of affairs. Is it not, Mr. Chaudhary? Do you feel any different? And this entire department with a huge number of personnel, this is the only work they have in for the government of Assam to do. If you do this, will the provision of the Supreme Court be not satisfied that the state can verify the facts and then lead evidence in rebuttal? Because if you lead the evidence, yes, Mr. X of that voters list, we have gone to him, verified from him. He says that this man is not his son. His sons are so and so, somebody else. Their names are appearing in his own voters list elsewhere.
Well, the state has to give evidence in rebuttal only. First stage is that they whatever documents they
Mr.
have
Nath,
given-
invariably all the proceedings discharge something or the other. You have to then evaluate that evidence, then see to what extent rebuttal is required. That evidence may not be exactly of 100 out of 100 in a scale. Suppose it is 50 also. Are you not required to give rebuttal to that 50? Or you allow that 50 to remain? Moment you allow 50 to remain, that will be a case of non-traversal under the law. Why don't you do it? So we want to lay the exact guidelines, what the tribunal is required to do, what the government is required to do, what the government leader is required to do. Instead of just participating in the proceeding and doing nothing, just take recourse to Section 9 that burden of proof is there, they have failed. And our burden is over.
Mere discrepancies here and there.
It will benefit,
May not be.
and mind you, there are Supreme Court judgments even on the name of spelling. I think it is Kematullah and Kefatullah, if I remember
2019
Yeah.
5 SCC 534.
the name of one person was stated is Kematullah, he is stated as Kefatullah, and that discrepancy was accepted to be a discrepancy, Supreme Court rejected it straight away. They say, please don't do it. In spite of that, the same thing is repeated.
No, these things possibly may not have been placed before the tribunal
We don't know.
from either side, my lord.
It is for it
This
is
is-
also for the state to
Yes, yes, of course, my lord. The Supreme Court.
And
has
what
already
is the
decided.
purpose, what is the purpose of these proceedings? To arrive at the factual situation, whether this man is a citizen or is not a citizen.
Whether
So-
he, lordship, whether the evidences adduced by the proceeding proves that he is a citizen, whether he discharges his burden. or
So
not.
whatever evidence is proved, don't you think that has to be rebutted in any manner? Or let it
It-
remain as it is, then pounce onto the theory of discrepancy and disbelievable and finish it off.
Should not be the approach. my lord.
Ultimately, see the number of matters are going back now. Both from the High Court as well as the Supreme Court. None of the superior courts have recognized it. So why don't you correct yourself at a ground level?
And
We'll continue at 2.
and even
Yes, madam.
lordship, even in paragraph 94 and 95
Of
of full bench order, Muslim Mandal also has relied upon the apex court few judgments, which says that
95.
with regard to the apex court, may I read out or after the
yes, we don't, if it's
the
not very
apex
long.
court in the Dwarka Prasad Agarwal Supra has opined that right to get a fair trial is a basic fundamental human rights. and
It's okay,
denied-
these are general propositions, we are not on that. These are general propositions,
And
it's always there.
Trial is different, my lord. Investigation, lordship.
We are on the specific, on the procedure that is adopted.
Procedure.
Not only
Now,
procedure, we want to
in fact,
delve on the duties and responsibilities
of
of the
the government.
proceeding of the tribunal of the
government.
state authorities.
But appreciation of evidence will vary from case to case. Ultimately,
Definitely.
a standard guideline has to be.
That's why I say,
Lordship. Because
although
the-
the theory of disbelievable is accepted in
No,
law, but it
no.
is very, very circumscribed.
Yes, yes.
Not that it is has to be applied at random without any reasons.
Just putting a certificate before the tribunal as an evidence will not suffice. Contents has to be proved.
We have already held it.
Yes, yes, it is for the.
No, in this
prosecution.
judgment only, we have already
Lordship.
held it.
Ultimately, the appreciation of evidence has to be.
Definitely. And once the police does this minimum exercise, don't you think it will be easy for all? There is also a possibility that the voters list presented is a fake voters list, non-existent. Who knows?
Certified copy they have to give. No.
Look at the condition of the certificate copy.
That document can very well be verified.
Look at the condition of the certificate copy. Plus, we are already having materials that some of the materials presented are also available in the market.
No, I am told Malad, that
In
the-
some cases, we have gone to that extent also.
Malad, the voters list, Malad, foreigners tribunal, I am heard that voters list foreigner tribunal is to direct the deputy commissioner to produce the copy from the office in respect of voters list. You know?
Nothing of the sort is happening. Nothing is happening. on that. The Home Department, the Election Commission, the Deputy Commissioner Office can work conjointly. Find out from their own records whether this list actually exists or not. If it exists, who all are the names there? Suppose X is referred as the father of 1966. 1971 shows that X had 2 sons. 1977 shows that that same X had 2 more sons and 2 more daughters, say. If the name of the proceeding is not included, that itself shows some little bit of doubt whether he is actually the son of that man or not, because his other sons' names are there. If you make a little bit of inquiry, can't you find out these facts? Will these facts be not good for rebuttal of this claim? But if on the other hand, this continuous list starts containing the name of the proceeding somewhere, there's a good indication that he or she also may be the offspring of that man.
Some instructions or guidelines may be available with the.
Then
authority
you
also.
go to the certificate.
We have to check
Another kind of material produced is the certificates.
certificate, various kinds of certificates.
Go and approach that Gambura or the secretary by the police. Ask him did you give this certificate?
But the moment we receive the certificate, if we start inquiring, it will create a problem.
Who?
It will create a problem.
Who-
Otherwise,
Will create a problem.
the entire thing will be imbalanced.
No.
It is not possible for the authority.
Go and get it verified whether actually that person had issued that certificate.
Our report will not be considered because the certificate, the person who has given the Gambura certificate, burden is on him to prove that the contents are correct. So he has to prove it. If we.
Mr. Nath,
Logic.
we don't agree what you are saying.
Logic.
If you see our judgment on certificate, what is the certificate and what is the legal implication of a certificate?
Yes.
Why can't you verify whether that man has actually, because in most cases, that man is not examined anywhere. We have come across cases where that author of the certificate is not examined.
Examination has to be there from the
That-
government side
that
also. They should
Author of the
chase.
certificate will be a man within the jurisdiction of this superintendent of police border. Why didn't you make a preliminary inquiry whether he had actually issued a certificate or not? If he had issued, put it in the next question, from where did you come to know? If you cannot give the answer, you come back and produce your own evidence before the court that we inquired that this certificate is not issued, or we inquired it was issued, but the man does not know from where he knew it. Would it not be of help to you? In other words, we are asking you why the department is not ready to do some work
That they have to do. They have to do.
instead of just
It's-
sitting over the matters.
True. There is no issue on that.
So that is the precise reason why you are taking up
True.
this matter.
True, Malad.
We'll come
They
back at 2.
Malad, at 2, Malad, there is a special bench in court number 1. Kindly give me some
You
information.
attend to that and then come back. But we recorded your views. You agree or you agree with that
Yes, yes.
whole theory of
No, Malad, we agree that ultimately the system has to be a
it
fair.
has to work.
True.
The truth has to come out.
True.
It has to be fair.
Yes,
These
yes,
are the only two
there
requirements.
is no second submission on that. I must agree.
So if the person is relying on false documents, it will come out. You put up your case before the tribunal.
But Lordship is passing the order to the Malad.
Yes.
But can we just verify whether from the government, because the tribunals are functioning, whether they have given already some standing instructions are there or not?
We don't get it. You can bring it.
But
Even if it is there, it is unworkable. It is not unworkable. Perhaps it is not working. Otherwise, the tribunal should have
not
proceeded in a different manner.
not working and not following are two different things.
Yes, not working in the proper manner. Working, no doubt.
And if it is not properly followed, then Malad, it will be different.
So we like to put in certain guidelines to be
Lot.
circulated. For the tribunal, for the government, both. And the role of that government leader also. He has to play some more proactive role.
That is there.
Please come back. We'll come back at 2.
Kindly accommodate me for some time more in the special bench.
Chaudhary, you may address the court.
Yes.
For his absence, what views of the central government, because you are
It's the same case. and it's-
okay.
But any, the moment it is over, I will just back Malad.
Okay.
At 2, that special bench is sitting. Malad.
You also submit in the meantime what you have to say.
Malad. Oh,
Oh. And my lord, before issuing notice also, lordship,
No, we are not expanding the issue. That we'll see in some other
yes,
matter.
because there has, because even in Sarvananda Sonowal 2 also it has been stated.
So that you take up in some other matter where
Yes,
notices are issued in a contrary manner.
Yes, Lordship.
Means don't,
Because
we don't
have
want,
students.
we don't want to add up issues.
Yes. Lordship. Yes, we want it to be
Yes, Lordship has pointed out rightly in this line, your Lordship, in paragraph 26, says all these facts should naturally be within the personal knowledge of the person concerned and not of the authority state. After he has given his evidence on this order, state authorities can verify the facts.
Which paragraph here? That para 26.
Paragraph 26 says, state authorities can verify the same, the facts and can then lead evidence in rebuttal if necessary. So they can very well verify, your Lordship, and in case if they have any doubt, they can also, in a detailed cross-examination, they can put questions on this document. As Lordship pointed out in many cases, while cross-examination, this was not being done. So those doesn't get filled up. during the
So
process.
even the voters list, we are not sure whether it's a good
sir.
authentic voters list or it is not a.
Because in some cases, I have seen, because the election department do contact me on certain occasions when they receive summons from the foreigners tribunal, they send persons with the copy of the voter list to the foreigners tribunal, and they very well verify the same before the tribunal that yes, this is the record, as per our record, this document is telling with you. But that procedure can very well be done, your Lordship. Even in just like in the civil cases, when the court call for the records, someone the same, because the department never denies that they will not reply to the summons, your Lordship. When the court summons them, the officials with a record, they will definitely come before the court and verify the voter list, your Lordship. That can be done in a very easy manner.
With regard to certified copy of the voters list, if it's a certified copy, Lordship judgment is there. It's made-
Madam, that is true,
Yes, Lordship.
but whether it is actually a
Genuine
certified copy or not. Because many things are happening,
Yes, your Lordship.
Yes.
many things are happening.
Because of certain person.
Whenever
when
we are
put
making
persons
some
are-
detailed inquiry into something, slowly it's very difficult to have the confidence that whatever is
Got it, Lordship.
provided is actually that.
Even few
Ah,
tribunals,
so-
they call
Hmm.
for the authenticity of the voters list from the state authorities. Sometimes the digital voters list. Yes, they said that they send the report.
Yes, wonderful.
Where is Mr. Pine gone? Or he works? Or do you work shift wise?
No, he's coming.
He is coming, madam.
No, they say that he's in some court one or something.
That matter has been adjourned. I would take your lordship only to two provisions of the act and this particular.
Of
If you-
which check, Evidence Act?
One is lordship 106 of the
Evidence Act.
evidence.
The
Act. That has to be-
person who knows the
Yes.
fact, the burden is on that.
No dispute on that. And
Hmm.
so far as this Foreigners Act, lordship, section 9.
Hmm.
like,
Supreme Court approves section 9
That,
by referring to
Yes.
section 106
Yes.
of the Evidence Act.
so that part is very clear.
Hmm.
Now, the procedure that has to be followed is
See-
laid down in section, in paragraph 26.
Some of the respondents are not very happy on the questions we are asking. We are aware of it.
That
We
time.
are aware of it. Don't worry.
So,
But question is, when we have noticed something,
That-
should we just shut our eyes and keep allow things to happen where it is happening?
that is what.
And mind you, Mr. Chaudhary, the implication thereof is that a good number of repetitions are allowed,
That is,
which we are required to allow under the law. But although we may know that in the actual factual background, that may not be like that.
mostly it is not that way.
Why? Because further materials are not coming from the state side.
That, lordship,
A little, if an iota of a material from the state would also been there on record, then we would have examined the two records before, two materials before us and then take a call. It is not there.
no, lordship, practically what is happening is, lordship, once the proceeding is before a tribunal or a court, everybody washes their hands off. We have got nothing to do now. Now,
Why? Because section 9.
no, it's, the court will look after it. It's come to the tribunal, it's come to the court, we are not going to do anything now. But that is precisely what is being taken care of in paragraph 26.
Yeah,
Yes.
the line that we pointed out, Supreme
Yes.
Court.
Now, so far as lordship, the evidence is given on behalf of the proceeding, whatever evidence, lordship. It is not that. Because we also go to the trial court, we have seen, it is not that the cross-examination happens on the same day itself. Now, what happens is, the party files a, let's say, evidence on affidavit. There's a break in between. A date is fixed for cross-examination. What has fallen from your lordship is very material, I would say. That time, why don't we utilize it to make some verification? Unless, because.
No,
Yes,
just what
Yes.
you're saying, we're just adding to it. Suppose this would have been a regular proceeding. Let us take, there is a civil suit between Mr. Chaudhary and us. Mr. Chaudhary comes and leads certain evidence, some document, some material, something, and establishes whatever stand is taken in the plaint. So I, being the defendant, we also is a participant of
that proceeding,
those events,
yes,
know my facts in a little different manner. And in a manner which a fact will support me.
lordship.
So I'm in a position to bring in my evidence, my materials to substantiate the way I look at the facts of that case. Fine. Why? Because I am already a part of that event which had resulted in that dispute being raised in the title suit. These cases, the state is not a participant in that event, except for an initially inquiry being made. Inquiry, they find it not to their satisfaction, refer him. So the state doesn't know anything beyond that. So when will the state come to know? Otherwise, the burden would have been on the state to prove. Normally, it is always the state to prove against the proceeding. So here comes the relevance of section 9 of the Foreigners Act. the burden is shifted to the
Proceeding.
proceeding. Because why? Because the state is not supposed to know. Para 25 is very clear.
Yes.
If the state authorities dispute the claim, say, if by a person and assert that he is a foreigner, it will not only be difficult, almost impossible to them to lead the first
Yes.
evidence, meaning thereby state does not have any material with them. Otherwise, the law would have asked, whatever material you have, you lead the evidence first. So when the law itself presumes that the state has no material with them, at a subsequent stage, while discharging the Section 9 burden, the proceedee has brought in certain material. What is the state supposed to do? You have no material.
Is
The
the
law,
first time the
and then
material
the
is
law
coming.
understands that you have no material. Subsequent stage, the proceedee has brought in their own material. What you are supposed to do? Are you not required to make an inquiry? Whether that material produced is an authentic, acceptable material or it is not. This is why the Supreme Court has provided that after he had given a state authorities can verify the facts.
Yes.
This is what we are trying to
That is.
understand from you.
What I was trying to place before your lordship. The materials first come in when the. party
And
adduces-
when situations are not conducive, the questions put by the court is always unattractive.
Lordship,
We understand that. But we have an onerous
Yes,
duty
yes.
to also venture into an unattractive situations. We always cannot accept everything to be attractive. Because we have our own duty over own.
Yes. Now, what I was submitting is, lordship, the first time that the materials come in
Hmm.
is when the party is the evidence.
That's
Some
why.
is a- Evidence and affidavit.
And when it happens, when the state has no material of their own, and law also accepts and understands that the state does not have material. So what is the next logical step?
Now, just as I was submitting, lordship, it is not that the day the evidence is filed, the party is cross-examined. There is a gap in between. Mostly what I see, what I find, lordship, there's a gap in between. Now, when the materials first come in, to prepare myself to be better equipped for the cross. Suppose I am the counsel for the state. To equip me better to do the cross, I have to verify.
That is what we are trying to.
I have to verify. And let us not go to the stage whether the tribunal is determining whether the documents are genuine, not genuine, can be relied upon, cannot be relied upon. But as a state counsel, I have to be sure about the materials and how I would cross him. Suppose for some reason, I cannot break the person in the cross,
Break that.
break the witness
Ah.
in cross. That is where I will lead my evidence,
Definitely.
but that perhaps is like lordship.
This is what we are trying to ask you. Had we got some more support from the state in the original proceeding, it would have been very easy for us to decide the issue. Now what is happening? Without there being any material from the state side, the only material produced by the proceeding is relied upon. A particular view is taken without any counter material. When this proceeding comes to the High Court in the writ jurisdiction, a particular material is pointed out. That this material is indicating that I am a citizen. What do? Send it back. That examine this material. This is happening for the last, in many number of cases. But if the counter material would have been available from the state in the original proceeding,
That.
maybe instead of sending it back straight away every matter. And mind you, when materials are presented, it's a question of perception. It's a question of perception how the tribunal looks into it. It's a question of perception how the state looks into it. It's a question of perception how the proceeding looks into it. So the tribunal and the state together without any further material expresses their perception. This is what we are getting in the form of an opinion of the tribunal. Now, when the proceedings are before the High Court, the other perception is projected.
That,
Ultimately, don't you think it is leading to multiplicity of litigations for nothing? What is happening? One round in the tribunal, come to the High Court. We say that from the perception of the proceedee, this is the view. Somebody please look into it. And for looking into it, if the state wants, you can bring in more material. If the proceedee wants, you also bring in more material. These are the common orders we are passing every day. Don't you think it's a waste of time for everybody?
I would,
Which could have been corrected in the original state itself.
a little bit of more professionalism
A
is
little bit.
required.
And this is what we are trying to ask you. Whether our questions are attractive or it is not attractive, I don't know.
Should
For Mr. Pying, it not at all appear to be attractive, it seems.
Whatever question lordship is putting me, I do not take it that way, lordship.
Don't you feel so?
No, but
Looking a little deeper into the whole.
I feel that, lordship, there is an opportunity given, which we are not taking advantage of.
And moreover, Supreme Court has made it very clear. And that too, when was this decision rendered? In 2005 itself. It's almost 18 years Supreme Court had laid down this proposition, but
Because
it's not taken seriously or not followed.
most of the proceedings, lordship, have not appeared in many cases, but whatever I have seen, the cross-examination part is lacking, and to do the cross-examination, we need to do some homework by way of some
Something,
verification.
otherwise, how will you cross if
That
you
is-
yourself don't know?
That is what.
Mr.
Yeah.
Nath, in fact, this is also what I indicated to Mr. Chaudhary. You see this further what section 20, para 26 has provided.
Well.
Hmm. If the state authorities dispute the claim of citizenship by a person and assert that he is a foreigner, take note,
Lordship.
it will be not only difficult but almost impossible for them means the state, to first lead evidence on the aforesaid points.
Point.
This is the underlying reason why Supreme Court approves with
Section
or justifies this provision of section 9.
9.
Because what the Supreme Police is doing, he finds somebody. In his mind, he feels that whether this man is a citizen or he's not a citizen. Goes to that person, asks him to produce whatever material he has. Either the person escapes or the person is unable to produce. Supreme Police refers it to the tribunal.
He has some doubt. That is
Why?
he says.
Because the superintendent of police does not have any material with him to prove that he is not a citizen or that he is a foreigner. Now comes in section 9. Moment section 9 comes in, the superintendent is in such a state that he does not have the materials with him. And the law requires now the proceeding to produce his material to substantiate that he is a citizen.
Yes.
Proceedee rightly, wrongly produces something before the tribunal. It's a genuine material, it's a fake material, it's a manufactured material, it's a relevant material, irrelevant material, it doesn't matter. He produces something. Unless this material is rebutted, the law of non-traversal will be applicable, firstly. It has to. Therefore, the Supreme Court taking note of the existing factual situation that the SP has no material, and also taking a presumption that the SP has no material, therefore he is not required to first bring his material to prove against the proceeding. Now has provided that the state can verify the facts. Once the whatever material is produced, once the SP goes and verifies this fact, how will he verify whether the facts depicted by the material is a right fact, existing fact, or it is not an existing fact? Two, whether the material itself is an authentic material or not. Both are possible. Once these two steps are undertaken by the SP, as what Mr. Chaudhary has submitted, he will be in a good position not only to cross-examine, but also to take his stand before the tribunal along with his materials. What will be his materials? He can say, I went and verified with the Election Commission district authorities that this voters list does not exist at all. This is a possible stand he can take. Or if the voters list exists, he said, I went and made an inquiry and found out that person X of that voters list, he is still existing, or he is not existing, now his children are existing. But from that material, it appears that this proceeding is not his children, because his children are A, B, C, D, whoever they are, and they are residing here or wherever they are residing. You have your materials with you. Don't you think we are in a very strong position to rebut the evidence of the proceeding? And all that the tribunal will now require to decide is based on the two materials. The onus will immediately shift to the proceeding again, shift back. Now you show any further material, whatever counter material is produced against you. If you cannot, state has made its point. If the proceeding brings it further material, again you.
If that, if that effort is put, Malad, some.
And mind you, the Supreme Police has a huge machinery at his disposal to do minimum this much. His lordship is also pointing out that in many cases, as there is no cross from the side of the state, the tribunal themselves put some questions on their own.
No, but that we have to.
Not only,
That we have to take up seriously, Malad. Because ultimately the advocates are there from the government side, Malad. They have to.
they have to do something.
That Malad we have to take up seriously, Malad. We will definitely take up.
Or maybe some kind of training is required. Some kind of guidance is required. What is to be done, what is not to be done.
Malad, that is for both. That is for the tribunal also, Malad, in my respectful submission, Malad. For the tribunal as well as the advocates, Malad, conducting the cases.
Tribunal, who is guiding them?
Members, Malad, they are immediately after appointment, they are attached with the earlier member. For 3-4 months, they used to sit with the member, existing member. After that, they are given separate codes. But during that particular 3-4 months, possibly they used to see how the proceedings are conducted by the earlier member, and accordingly they adopt the same thing, and they used to follow that. Otherwise, those are all lawyers. The new members.
I know.
Some retired judicial officers are there, Malad. They are of course there, but most of them
No,
are-
otherwise, are they being guided by anyone, or they are absolutely unguided on their own?
Training procedures. Short time, 3-4 days or weekdays training is sometimes given to them,
Somewhere given.
sometimes. given.
But last.
No, just me, Mr. Pine, this side.
Within a sort of like one, right?
My lord, earlier there was some training in every year, my lord.
Huh.
But last 2-3 years.
No, no, but what happens is, as the matters progress, more and more issues, more and more problems, they come up.
Yes.
So there has to be some kind of a continuous process of this input trainings also.
Last
Training
2-3 years, there is no training, my lord, after, from the COVID period.
Because what happened, these tribunals are already in a particular state of mind. And they're acting accordingly.
Like, we have a monitoring bench, my lord, monitoring bench, earlier the monitoring bench used to, my lord, conduct the, my lord, initiate the training, my lord. With
But
collaboration of.
initiation is long time back. Now it's almost about 8
Yes.
to 10 years, I suppose,
Yes, yes.
of existence of this tribunal.
2015 or.
But these are happening in course of their
Yes, yes.
proceedings. Now it's becoming noticeable.
Even for AGPs also, there were 1-2 training, my lord, earlier, but last 2-3-4 years, no training. In fact, in some tribunals, my lord, there are no AGPs. That's why the, my lord, only for clarification, my lord,
The tribunal, they put the
tribunals are asking.
questions.
Under section 165
Under 165, it is,
65.
my lord, evidence.
Evidence Act.
Means number of government pleader is less than the number of tribunal.
Yes, my lord. One more thing,
In Kamrup Metro, we
There are
have
also-
5, only 2 AGPs are there.
there is still like. One thing, my lord, it's out of record. The fees there is very less, that's why more probably.
It's a, also the no.
it's a nothing.
Then let the superintendent of police, through his designated personnel, let him himself attend to the tribunal. Because lawyers, they act on the basis of a wakalatnama, meaning they have a power of attorney holder. But the original is the litigant is that.
Yes,
officer.
As superintendent of police, as me concerned.
He can also come and take note. Suppose in a given case, there is no government pleader. A designated official by the SP. How many tribunals are there in every district? About 10?
In some districts, 4-5, my lord.
And some districts, say up to 10.
Yes, up to.
So
10.
he'll have to deport 10 personnel. 10 personnel, definitely he must be having at his disposal. He'll only take note of that these are the materials produced by the proceeding. Now, go back to his office and then make inquiry or find out or get it verified also whether this material is good or not, and then take his stand straight away. This certificate not admissible because of this reason. This certificate by the Gaon Bura, we see no proximity of the Gaon Bura having any knowledge about this person. Don't accept it. Ex-voters list, it does not exist. Another voters list, it exists, but a person is a different person. I have met him. He is surviving his own life elsewhere, else he is not this person claimed to. End of the matter. You just have to bring this small information to the notice of the tribunal. Tribunal will put the question back to the proceeding. That the person you were relying from the voters list is somebody else. He's already been, we have already met him. He's somebody different, not this person. And this arises because in most of the cases, the materials Yes, Mr. Payne? What kind of order
My lord,
what kind of order you expect? Let it remain the way it is, or you bring in some little bit of the
only my,
required.
my submission, my lord, to one thing, my lord. Let, first of all, let them bring the evidence, my lord.
Who?
Once the proceeding, my lord.
Ah,
let them
definitely,
pro-
that is
Yes,
always there.
Yes,
Ah.
and let them prove it first. If necessary, then we'll rebut, my lord, that must. Because the documents, whatever, my lord, the
Mr. Payne, this is,
admissible, if the
Mr.
evidence
Payne,
is
this
admissible.
is the difficulty. When you say if necessary, that is your perception at that moment.
No, obviously, my lord, we'll make an inquiry on our part. my lord.
Ah,
That is our
this
internal
is
part.
what we are trying to
Yes,
ask you.
that is an internal part, my lord. That is our internal part. First of all, my submission is that let them produce a manner admissible evidence, my lord. Admissible, relevant, and my lord, and which is to be proved.
Everything is admissible. Which evidence is not admissible? Tell us.
Yes, my lord. Suppose a document.
How
which
do
is-
how do you difference between admissible evidence and non-admissible evidence?
Your lordship has seen, my lord, some concert certificates which have stat emblem.
This is what I am saying. Now, we will take a call it is admissible or not. Only when you bring in rebuttal. Otherwise, the law of non-traversal is applicable.
Objection must be there. my-
This,
Objection must be there.
but this is not forthcoming.
My lord, this is, in fact, this is advice to the, my lord, AGPs during the time of, my lord,
But it is not forthcoming. That is the difficulty.
this is advice to the AGPs during the time of, my lord, training.
Otherwise, suppose the proceeding comes and takes a stand that law of non-traversal is applicable, let me accept everything what I have said. What will the court do? Now, Mr. Pine, just come to the facts of this case. This will be WPC 5307. The petitioner, you want the records? You have it. Okay. Petitioner refers to 66 voters list of village 129 Baladmari Part 4. Okay.
Please, madam, please.
I don't know.
66
I'm
voter list.
referring to my note. It must be there somewhere. Let's take a. There, at serial number 7, the name of serial number 6, late of Kobad Akand. Okay, son of late Sarafuddin.
So,
And serial number 7, Fuljan Nessa. 1970 voters list is also same. Fuljan and Kobad Akand. Then one person comes in, Karim Akand. Where is the name of Karim Akand?
97, it's in the record.
97 voters list
Yes.
of Baladmari village.
Yes, same.
So Baladmari village is Karim Akand.
Yes.
Karim Akand's name appears along with, I think, Fuljan Nessa.
Fuljan Bewa.
Fuljan Bewa, because Kobad Akand died in the meantime. Karim Akand comes and adduces evidence that the proceedee is his sister and daughter of Kobad Akand. Now, if this much of evidence is brought before the court, if we accept it as it is very true, Karim Akand has come, his name appears with Fuljan Bewa, wife of that Kobad Akand. Kobad Akand is there in 66 voters list, and he says that so and so is my sister. We are bound to allow it. Yeah, definitely.
my lord, for the sake of monetary, my lord, may kindly see the WS filed by the petitioner, my lord, at page 16. What the problem here is, my lord, what the tribunals are, my lord, going beyond against that, my lord. Neither in the WS nor in the evidence of, my lord.
So this is a very, very strict technicality of a civil CPC, that a stand that you don't take in the WS, you are not allowed to adduce evidence on that.
I'm not on that, my lord. As para 27 has says, it is her special knowledge, my lord, that she has a brother, she has a sister, whatever, my lord. It is her special knowledge. She has to specially say all these things in her pleading, whatever it is, either in the WS or in the written statement or wherever. But she has nowhere said that she has a brother called Karim Akand. She has nowhere said, my lord.
Very well.
My lord-
Suppose she has nowhere said, but the brother exists. Will it be a proper justice rendered? Just because you missed out in stating that you had a brother, now you cannot bring your brother in evidence under any circumstance. Just
Yes, yeah, I understand.
will it not be a travesty of justice? Suppose this person is a genuine Indian citizen, what will she feel? And mind you, these people are almost of the level that most of them are not very literate to know all these. They are guided by a set of lawyers who also may not be that competent in all these technicalities of law. Or maybe the lawyer is a little superfluous. He takes things lightly. Faith, do you mean to say you will send this lady out of the country? You are not a citizen now. Do face whatever consequence you have to face. Will it not be better if you follow Supreme Court and moment this evidence is rendered, take one date from the tribunal that we want to make a verification?
That can be.
Let the police go to this village, Baladbari. After going to village Baladbari, you will find out whether Kobatakan existed or exists, whether Fuljan Bibi or Fuljan Bewa in the meantime actually exists. After going to their house, you know the house number also. After going to the house, if you find that their family is something different, they're enjoying to themselves, they are no way related with this one, nor they have any son called Karimakan. Can't you put your verification report before the tribunal?
That can be done. madam.
Once
Definitely.
this is done, whether Karimakan is the brother or not will be very clear. If he is not the brother, the whole case falls through.
Definitely.
If he is actually the brother, and from that verification, we can also find out from that family whether this proceeding is their daughter or not. You can ask the neighbor, you can ask that, you can make a lot of inquiries. Suppose doing everything, you come to a conclusion that no, this family does not have a daughter called like this. This family does not have a son called Karimakan. Their children are different. They are leading their own lives. You just have to produce this, that we went verified that the Kobatakan son are X, Y, and Z, not Karimakan. Their daughters are somebody different, not this lady. Everything goes.
In that case,
And
my lord, they will-
suppose the tribunal gives a judgment on this material, no court is going to interfere with it. You can be very sure. Number two, you come to the certificate issued by the Gaon Panchayat. The Gaon Panchayat certifies that her father's name is recorded in the electoral roll of 1966. Put a question to this man, either bring him for cross-examination or you make your own verification. From where you came to know?
As far as possible, my lord, the process done, but in some cases it is not done.
No, just put a question. What is the source of your knowledge
Yes.
of making this statement that Kobatakan is of 66 voter list is the father of the petitioner? What is your source of knowledge?
In some tribunals, it is done, my lord, but in
But
some
do it
cases-
in all the tribunals.
But my lord, in maximum cases, my lord, even in this case also, the Gaon Bura was not brought before the tribunal for cross-examination. Probably.
If the Gaon Bura is not brought, we'll allow them to bring the Gaon Bura. Not Gaon Bura, I think Panchayat secretary.
Panchayat secretary was not.
We'll allow him to bring cross-examination from, you have show him the certificate. You have given the certificate. Have you written it like this? From where you came to know?
That's that part, my lord, that's why I'm submitting, my lord, that is there, but first of all, they have to prove this.
Again, you are back to square one, Mr. Paying.
We'll make an internal inquiry, my lord, even then if they cannot.
Okay, then we allow this writ petition. We take note of your submission and allow this writ petition. We declare her to be a citizen. This is a good material she has produced.
That is a different case, my lord.
Not, if you don't want to verify, if you don't want to cross, if you don't want to do anything,
But we'll verify, my lord. I'm not saying we'll not verify.
we accept your statement, Mr. Paying, and we allow this petition.
And
Because unrebutted material is good enough for a declaration for their favor. Okay then. So in the end of the day, we take that you are objecting to this one also, right?
We are not saying, my lord, we are objecting. My submission is that, my lord, we can verify, definitely you can verify, my lord.
Not can, you should.
And, my lord, only thing
And
is
not
that-
only that, we'll also observe that the requirement of the law laid down by the Supreme Court is also not followed. We'll put it in our observation. And the state is reluctant to do this. So our only order is unrebutted evidence, we allow the petition. We don't even send it back also then.
We'll definitely cross this, my lord.
You do it, this is what we are saying. And you should have done it at the first instance. Not after the High Court sent it back.
That's why, my lord. But, my lord, the notice has to be given by them to the, my lord, proceeding, that you come, because unless they come, it cannot be proved and we cannot cross. And verification is a different part, my lord, will verify, but in the court, in the tribunal, they have to.
Verification is most important.
Yes,
Because there may be many number of cases where false claims are made.
yes.
And the horse your verification, that false claim will be accepted by the court on the principle of non-reversal.
The lordship may direct that part, will verify.
Plus, there is a mandate of the Supreme Court. You are bound to do it. Also keep that in mind.
Only
It's
verify.
not your choice. It's a mandate of the law. So what are the duties and responsibilities of the government leader and the superintendent of police? We'd like to add in the order. No, we want it from you.
After receiving the, my lord, reference in the tribunal, the government leader should go for cross, and first of all, my lord, they will have to go through the whatever record is there.
And if the author of the certificate is not examined, Supreme Court had already held. It has no evidentiary value, that
Yes, Lord.
certificate. That is, onus is on you to
Yes,
bring him on,
yes.
if you want to rely on certificates.
My lord, that's why I'm submitting, my lord. We'll verify on our part. First of all, we'll verify. Once, my lord, that should be the duty of the my lord, investigation officer. In fact, the SP concerned.
Verify each and every aspect,
Yes.
not just one aspect.
After filing of evidence by them, my lord, we'll verify the evidence.
Right.
Then we'll go for cross. That can be laid down. But only thing,
And lordship, here DW two also is there.
Iman Ali Devani,
Yes,
and the name of the father is not legible.
yes, lordship. But
So we have to discard him.
handwriting, it's not the fault on the proceeding. Member has written in that manner.
You get a certificate from the member, what is the name there? Only he can read his own handwriting, no one else.
Inna Ullah Akon, I think. South Street, Inna Ullah Akon. In Akon it was by so.
আমি তো পরিবহন বাড়ি লেগে পেলাম না যেটার নাম তো পরিবহন বাড়ি
Iman Ali, আমার son of. একটু পড়বে।
my lord, last time I did, therefore, one thing I had submitted before your lordship. That my lord, my submission is that there may also be a direction to the petitioners. Because there is,
with direction to
my lord, that they may submit the, my lord, list of witness immediately after the WSS file. Otherwise, my lord, it will be difficult for our part to make my lord, because if,
no
my lord,
no
if
once
If
There
list
are-
of witnesses given, my lord, that
I
they
understand.
cannot
There-
bring,
there-
my lord,
there-
these some bogus
understand.
witnesses. my
Mr.
lord.
Paing, there are two kinds of witnesses in these proceedings. One, a witness whom you have in mind when you file your WS. That so and so will give evidence in my favor in this respect. Second one is, you have it in your mind that I'll obtain a certificate from the Gambura or this one or that one. He may give, he may not give. Certificate may in your favor, may not be in your favor. You may exhibit, you may not exhibit. After you exhibit, then the question comes of examining that man. This definitely cannot be, may not be beforehand.
That's why, my lord, as soon as, because they are filing the documents,
Hmm.
along with the documents, along with the evidence also. My lord,
Suppose they give the name of the witness, what will you do? You'll go
my lord,
and you
why,
go
why
to
it
that
is necessary?
witness.
My lord, then this Korim like this, my lord, because Korim has suddenly appearing. Then, my lord,
What do we don't?
Korim is suddenly appearing here in this case, my lord. We don't know. We don't know whether he is a brother or sister or not, my lord. So in that aspect, my lord,
No,
this kind
no.
of some witnesses will not come, my lord.
Mr. Paing,
Who is a
your en-
doubtful witnesses
your
will not come.
entire difficulty with Korim would have been easily sorted out had you made a verification in the house of Kovatakan. This problem would have been sorted then and there. Once you verify in the house of Kovatakan, who is he, who are his family members, then if one Korim comes and makes a claim he is Korimakan, you can easily confront him saying that you are not the son because we have got it verified. He has only 4 sons. These are the names. You are not their son. Difficulty is the lack of effort at that stage. Everything boils down to para 26 of the Supreme Court judgment. Where is that Supreme Court judgment on certificate, Panchayat certificate? Justice
Ah.
Gogoi judgment, I think.
Yes, Lordship. I have the, I'll forward, I have the soft copy. I'll just forward. You just forward. to me, you just-
Mr. Pang and Mr. Nath, this judgment which you already dictated one part the other day. We have discussed what is an affidavit. What is the evidentiary value in an affidavit? What are the requirements of an affidavit? No, of a certificate, I mean, of a certificate. Go through it. Which was one.
Rupjan.
Rupjan Dev.
2018 one SCC 579. 2018 one SCC 579.
579.
579.
Okay.
Vikas.
So do you want to examine the Gaon Panchayat secretary?
Yes, Lordship.
After para 7 likhi was. After para 7. Yeah, coming already dictated judgment to us.
Just in addition to what Lordship has proposed, but in addition to that, the procedure for disposal of question is already also given in the order of 1964. Under order 3
Huh.
of the Foreigners Tribunal orders 1964.
We'll look into that.
Procedure for disposal of questions.
Hmm.
A detailed procedure has been given.
Okay.
It is already
So
there.
we reiterate those procedure and also require the tribunal to follow it.
Also add what Lordship has today indicated, that from
But
our
this
side.
verification part, we feel is very important.
Because
Not only saying for the interest of the state, it is important. Because otherwise, these things will remain this thing open-ended question all the time.
yes, yes.
In Wharton's Law Lexicon, 16th edition, a certificate is defined as extracted. You have to extract kori lobo. Tailor on evidence আছে নাকি না না কিরকম student certificates and measurement copies are admissible in evidence. আমার ইয়াতে আছে নাকি লাইব্রেরিত নাই Tailor on evidence. I don't think so. I can use it for some reason. Do you have that book? Tailor on evidence. Okay. এইটা লিখিব হ্যাঁ খালি কোড করে থৈ From the aforeextracted definition of certificate, it is discernible that a certificate is a testimony in writing to either declare or verify the truth of anything or where a fact is formally attested. If a certificate in writing declares or verifies the truth of the existence of any fact, or where a fact is formally attested, a natural question would also arise as to what is the source of the person of the existence of such fact. The source of the person who issues such certificate about the about the source of such person issue about the existence of the fact. After paragraph paragraph 13. In Rubjan Begum versus Union of India and others, reported in 2018, 1 SCC 579. Comma. The Evidentiary value of a certificate issued by a Gaon Panchayat secretary was elaborately discussed. In paragraph 12 of the judgment of the Supreme Court in Rubjan Begum Supra, the origin of the relevance of a certificate issued by a Gaon Panchayat secretary was discussed, and the origin of the certificate can be traced back to the provisions by the Registrar General of India with regard to issuance of such certificate. Anything else in it? From the aforesaid materials, with regard to the communication from the in this respect will recover blank then you write with respect to the aforesaid materials, comma, it is discernible that originally the provision of a certificate being issued by the Secretary of the Gaon Panchayat relates to a married woman as regards her parental home and her marital home, and where she was required to have shifted pursuant to her marriage. Mr. Paing, take note of what we are saying. And you also follow it in the tribunal. The certificate by the Gaon Panchayat is only to be issued to a married woman, not to everybody, whoever comes before it, to establish as to where is a parental home and where is a marital home after the marriage, only for that purpose. Not to declare a man citizen or not.
Verification of NRC, it was for the verification of NRC.
And even in Rubjan Begum, Supreme Court had, although not in so many words, taken note of it, that it originates from the letter of the Registrar General of India. It is for a purpose. In the aforesaid context, in paragraph 15 of its judgment in Rubjan Begum Supra, the Supreme Court had provided that the certificate issued by the Gaon Panchayat Secretary merely acknowledges the shifting of residence of a married woman from one village to another. In paragraph 15 of the said judgment, it is also stated also provided that the certificate issued by the Gaon Panchayat secretary by itself and by no means establishes any claim of citizenship of the holder of the certificate. And in the provisions regarding the NRC, the certificate by the Gaon Panchayat secretary is included in the illustrative list of documents, and by specifying it to be only a supporting document and not a document which establishes any citizenship. It further provided in paragraph 15 that a claim accompanied by such certificate from the Gaon Panchayat secretary without details of the legacy of the person is to be discarded. And the certificate is to be used only for the limited purpose of providing a linkage after due inquiry and verification. In paragraph 16, it is reiterated that a certificate issued by the Gaon Panchayat secretary by no means is proof of citizenship. Full stop. In paragraph 16, it is in paragraph 16, it is provided that a certificate issued by the Gaon Panchayat secretary has to be verified at two stages. The first is the authenticity of the certificate itself, and second is the authenticity of the contents thereof. The later process regarding the authenticity of the contents of the certificate of the Gaon Panchayat secretary is viewed by the Supreme Court to be an exhaustive process in the course of which the source of information of the facts and all other details recorded in the certificate will be ascertained after giving due opportunity to the holder of the certificate. And if the document and its contents are subjected to a thorough search and probe, no reason can be seen as to why the said certificate would be unacceptable. Full stop. The contours and within which a certificate issued by a Gaon Panchayat secretary can be acceptable had been clearly provided by the Supreme Court in paragraph 15 and 16 of its judgment in Rubjan Begum Supra. It is noticeable that once a certificate by the Panchayat secretary of the Panchayat is produced and relied before the tribunal, there is an inherent requirement of the authorities, and more particularly, which can be discharged only by the state authorities, to make a thorough verification as regards the contents of the certificate of the Gaon Panchayat secretary. Further, there is also a requirement to arrive at a conclusion as regards the firstly, as regards the authenticity of the certificate, and secondly, as regards the authenticity of the contents. Both the requirements in the view of the code would bring in and a further invariable requirement to have the author of the certificate, that is the Secretary of the Gram Panchayat, to be examined, to be also examined before the tribunal. Upon the Secretary of the Gram Panchayat being subjected to being examined by the tribunal, the state authorities in their wisdom can cross-examine the Secretary of the Panchayat to the extent as may be required in a given circumstance, so that the veracity and correctness of the contents of the certificate can be brought out. In doing so, as already held, that the author of a person issuing the certificate should also disclose his source of information as regards the contents of the certificate be also adhered to, and in such cross-examination, or cross-examination of the Secretary of Gram Panchayat, the Secretary may be required to also disclose the source of his information as regards the contents of the certificate. Yeah. We'll ask you to go and examine him, and you also examine the correctness of this thing, make a thorough inquiry. In view of the above, upon the matter being remanded back, the writ petitioner proceedee is given the liberty to bring the author of the bring the Secretary of the Gram Panchayat, who is the author of the certificate, to render his evidence for the purpose as indicated above. In the event the writ petition proceedee do not or fails to bring the author of the Secretary of Gram Panchayat for his examination, no evidentiary value will be given to the certificate that may have been produced. The state authorities through the Superintendent of Police Border is also directed to make a thorough inquiry on the acceptability and on the authenticity of the certificate issued by the Council Secretary, as also the authenticity of the contents of the said certificate. You also make an inquiry. The result of the inquiry that may be made through the Superintendent of Police Border be also placed before the tribunal.
May I submit?
That verification by the SP, that will be used by the government leader for the
For their
use.
No, they can bring it as a material, they can use it as a
No,
cross, they can use it as their own oral evidence to the person making the inquiry also.
Their evidence will come at the later stage, after evidence is complete.
No.
Otherwise the burden of proof will go to them.
No, this is a parallel inquiry.
But that is why.
Mr. Nath, we understand your question.
Logic.
One, they will produce. Once they are produced, they will examine. State will cross-examine. Parallelly, state will also make their own inquiry, because Supreme Court said that inquiry is required. Read para 16.
Yes.
The later process of verification is bound to be an exhaustive process. This verification will be done by the state. Para 16 of Rupjan.
Yes.
Yeah, para 15, 16 of Rupjan to court kori soy dibo.
Lordship, one submission, tribunal will issue someone, will file a petition accordingly.
Definitely.
Usually they don't allow a few tribunals, so we will file petition.
They are bound to allow, and they cannot disallow.
Because my experience in tribunal one in rural, did not allow in one of my case, which is now pending before this honorable.
It is clarified that in the event any application is made by the proceedee to the tribunal requiring the author, requiring the Gaon Panchayat secretary who would be the author of the certificate relied upon to be brought in before the tribunal as a witness, the tribunal should allow such applications.
CPC is followed for the purpose of notice and all, summoning no witness.
So let them,
It has to be-
because these are
It has to
little,
be there.
it is there the provision of, see, first is the authenticity, second is the authenticity of content, later process.
This particular sentence, Malad, the first is the authenticity of the certificate itself, and the second is the authenticity of the contents thereof. Two things. The
So you
later,
verify both.
later process,
Why don't you verify?
it is on the burden is on them, Malad.
Burden is on them, but the burden is also on you. We
Malad,
provided.
Malad, the honorable court, while stating here, Malad,
Ah.
it said that authenticity of the certificate is number one. Secondly, the contents of the contents, second is the authenticity of the contents.
Nath,
contents.
why are you in a bargaining spree for little give and little take? It is for the interest of both,
Malad, yes, yes.
and you have a huge machinery at your disposal.
Malad,
Why
in-
don't you
in-
use your machinery?
In comparison to the number of cases and the documents filed by them in every case,
Do it. You take
possibly the-
enough time you need.
possibly the burden, ultimately
The-
the. process.
No burden. If you do not do this, we accept that the certificate
They have,
as being,
they will do,
that there is no rebuttal.
they will do. But that will be, that their inquiry, that will be for the purpose of,
For your own
for
purpose.
cross-examination.
For-
Otherwise, Manoj, what may happen, Manoj, just come, it is coming to my mind, Manoj, I'm making, that is why I'm submitting, Manoj. But the inquiry, they will start asking the inquiry report of the SP, give us the inquiry report.
Who?
The persons, Manoj, the
No,
procedure,
they cannot ask.
if it is a
They
statutory,
cannot ask.
if it is a statutory inquiry,
Mr.
Lordship.
Nath,
Lordship.
no one can ask any inquiry report from you. If you rely on the inquiry report before the tribunal, only then they can ask.
Malad, if suppose if the inquiry says whatever,
You are
if-
thinking too much. Let the problem come first. This is not inquiry report, verification for your own satisfaction.
yes, that
Why don't you do it?
no, verification, Malad, instead of verification, I am putting the verification, that verification report. what is the
Mr.
report?
Nath,
For the purpose of
Mr.
that,
Nath,
Lord.
moment you file an affidavit,
Lordship.
we also apply our own verification mind. Whether the document you have annexed is a good document or not. Everybody does verification. Even we do it. Moment you produce a document, the first thought is, what is this document? That itself is a verification. And what you are referring is an elaborate inquiry
No,
report.
my lord,
We are
my
not on
lord,
that
my lord has directed the
to verify.
authority to verify.
Our word is verified.
Inquiry possibly.
And this is consistent with para 16 of the Supreme Court.
Lordship.
And you cannot avoid it.
Lordship. No, we are not avoiding, I'm just, my lord, submitting that this will be for the purpose of cross-examination of their.
Mr. Nath, after verification, for whatever purpose you use, it is for you to decide. If you do not want to use, you may not use also.
My lord,
It is for you to decide. Only thing, the implication of law will follow. That's all. You may not verify also. That is
But
absolutely your
this-
discretion.
This is in addition to rule 3 of the order. my lord.
Rule 3, we are not going. Statutes is already there. We
Statutes-
don't have to
statutes.
reiterate anything. Yes.
Lordship, one thing, if the author of this certificate at present, because the government servant, he might be transferred to some other panchayat.
Oh, no, author has to come. Otherwise, it has no
Yeah.
value.
Yes, Lordship, this,
Or expert.
One has to, author has to come. Otherwise, certificate is no meaning.
yes, Lordship, this one query, because now it's almost 7 years,
Hmm.
is to issue.
A certificate divorce the,
Yes, Lordship.
then you go and get a fresh certificate from whoever is available.
Yes, Lordship, that also, yes, that will be better. That observation may be there.
We don't observe anything.
Okay.
Observations are not ifs and buts and possibilities in future. You can't go on.
Then I may allowed to adduce further evidences, any documents also.
Yes.
Why did I have to remember the scene of liberty? Photo के अंदर इनकी verification तो पता है इनका भी pressure verification enquiry
It would talk, not up to them, some of them. There will be no delay. लेकिन ये हेरी episode हुआ हमने para 13 episode. Para 13 episode, we allow them this thing. Delete para 14. Para 14 delete. 15 will remain, 16 will remain. This is how we work.
Yes, it's verification for their own purpose. No? Okay, सभी विचारी बोले कौन से जो तब से तुम्हें समय पैसा वेरीफाई करेगा तभी लोग जानेंगे कि मैं तो कौन से वेरीफाई करेगा हाँ ठीक है ठीक है ठीक है वो तो मान के तुम्हें कहने को कमान दे वेरीफाई करेगा हाँ अभी वेरीफाई আমি করি ওরা আমার পারবে জানা জানা করা
After para 22. We have noticed that these proceedings before the Foreigners Tribunal are governed by Section 9 of the Foreigners Act 1946. Section 9.
Service order 3 minute. Sir,
Not order, act.
Act.
Section 9.
Section.
Section 9 of the Foreigners Act 1946 is extracted as below. Para. A reading of Section 9 makes it discernible that in such proceeding, where the question of determination is whether any person is or is not a foreigner, or is not a foreigner of a particular class or description, comma, the onus of proving that such person is not a foreigner or is not a foreigner of such particular class or description, comma, notwithstanding anything contained in the Indian Evidence Act 1872, comma, would lie on such person against whom the proceedings are initiated. In other words, contrary to the provisions of Section 101 of the Evidence Act 1872, the burden to prove the existence of the fact that such person or a proceeding is a is not a foreigner. কি বলবো sentence টো? Burden of proof as regards the existence of the fact would lie on the proceedee. And not on the state authorities, although the proceedings may have been initiated on a reference being made by the state authorities. In the circumstance, a question would arise as to what would be the further role of the state authorities upon the proceedee having discharged the burden under Section 9 of the Furnace Act 1946. While discharging the burden, the proceedee may have discharged the complete burden to prove that he is not a foreigner, or the materials and documents that may be produced and relied upon can also be construed to be not a complete discharge of the burden, but to be a discharge in part, or to be short of the complete burden. In the circumstance where the proceedee discharges either a part of the burden to prove that he is not a foreigner, or where he discharges, according to him, the complete burden, in such circumstance, what would be the further role of the state authorities? In this respect, we refer to the provisions laid down by the Supreme Court in paragraph 36 of its judgment in Harvananda Sonwal versus Union of India and another, reported in 2005 SCC 665, which is extracted as below. A reading of the aforeextracted para 26 of the judgment of the Supreme Court in Harvananda Sonwal Supra makes it discernible that after the proceedee had given his or her evidence to discharge the burden under Section 9, comma, the state authorities can verify the facts and can lead evidence in rebuttal of such evidence. A reading of the said provision makes it explicitly clear that once the burden had been discharged by the proceedee, either incomplete or in part, comma, it is for the state authorities to make a verification of the facts, materials or documents of the facts, and the authenticity and acceptability of the materials and documents that may have been produced, and to lead evidence in rebuttal thereof. The further provision in paragraph 29 that if the state authorities dispute the claim of citizenship by a person and assert that he is a foreigner, it will be difficult. It will not only be difficult, but almost impossible for the state authorities to first lead evidence on the aforesaid points. The said provision itself makes it clear that there is a presumption that in these proceedings before the Foreigners Tribunal, the state authorities may not have any material of their own to establish that the proceeding, to assert and establish and assert that the proceeding is a foreigner. As there is a presumption under the law that the state authorities may not have the necessary material and document with them to assert that the proceedee is a foreigner, there is more the necessity in the event of any material being led by the proceedee before the tribunal for the state authorities to verify the authenticity and applicability of such material in the proceeding. As already observed by the Supreme Court in Rupjan Begum Supra, the authenticity of the material would again have to be in two parts. That is, the authenticity of the material or document itself, and secondly, the authenticity of the contents of such material or document. In the aforesaid circumstance, comma, for a more appropriate adjudication of the proceedings before the Foreigners Tribunal, it would be apposite on the part of the state authorities, as well as a requirement of the tribunal to insist upon that the state authorities make their own verification as regards the documents and materials that may be relied and produced by the proceedee in discharge of his burden under Section 9 of the Foreigners Act 1946. And upon such materials and documents being relied and produced before the tribunal, the state authorities to make an inquiry on the authenticity and acceptability of such materials and document. And thereupon, if found that the materials and documents so relied upon and produced is either unauthentic, or its contents are incorrect, or they are not applicable in respect of the proceeding as may be claimed by the proceeding, the same be brought forward before the tribunal so that appropriate adjudication can be made on the issues raised. In this respect, we see a much greater role of the assistant government pleaders who appeared before on behalf of the state authorities before the tribunal, as well as that of the authorities through the office of the superintendent of police border of the respective district. It is stated that in many number of tribunals, the assistant government pleaders are not appointed, which may inhibit the requirements of the procedure indicated above. We further provide that in such tribunals, the superintendent of police border may make arrangement of an appropriate official of the police department to remain present in such tribunals, so that the official can take note of the requirements of any verification to be made by the state authorities for the purpose of rebuttal of the evidence that may be led by the proceedings. I think this is fair enough, good enough. On the other hand, if the state authorities upon the materials and documents being relied upon and placed by the proceeding is of the view that such materials do not require any verification, it is for the state authorities. But again, in such circumstance, the materials and documents produced should be appreciated on its own evidentiary value rather than seeking to discard the same without any acceptable reason under the law. Suppose something is so atrocious that it is, the document is self-conflicting. He says my father is X, but the document is showing not X, but it is somebody Y. Then you did not, you point out then and there, this is not your document. But if there is a semblance of an indication, better go for verification. It will make the-
Not to act on minor discrepancies.
Ah.
It is all right.
What are the two Supreme Court judgments, Kamatullah and that is? Let us have those two. In this respect, where is the precise line? Age?
Paragraph 9.
No, this is Sirajul Haq. But in this matter, the Solicitor General also appeared for the state. For the Union.
This minor discrepancies has been.
Ah,
Minor
So
discrepancies, we are also protected.
that you don't go, because what is happening, Mr. Payne, the concept of minor discrepancy is getting expanded slowly.
Yes. That's why.
Any discrepancy is now brought within the.
Minor discrepancy.
Mm,
Here it is Kapatullah become Kamatullah minor.
Ah.
That must be. The difference is
No,
that.
this one is not Kapatullah. This one is Kapatullah and
Yes,
Kamatullah.
Kapatullah become Kamatullah.
Uh-huh.
F
Say
become F.
someone,
We
one,
are not
say,
objecting that.
see, in one case yesterday, one Sokumuddin, he became Sokufuddin.
That can be. But,
And,
but Sokumuddin Ali and Sokumuddin Ahmed will be a different.
but there you make verification.
Yes.
Yeah.
They are.
Instead of going that you make verification. You can always say that we made a verification and found that X Ali and X Ahmed, they are not the same person. Then the owners will go to them straight away. In other words, Mr. Payne, do a little further work, again shift it to them. You'll be more foolproof in your presentations.
That's true, my lord. Our AGPs, they have to be.
Then our burden will also be less. And now see, most of the matters, we are sending it back. Once we send back, at least in one matter we came across, once it was sent back for a particular purpose, same mistake was done again. Again, it came back to the writ petition. For the second time, it was sent back. We are only increasing the number of pendency of the cases, nothing else. Okay. Yeah. People. A reference is also made to the pronouncement of the Supreme Court in Sirajul Haq versus State of Assam and others, reported in 2019, 5 SCC 534, wherein in one of the document, a person was indicated as one inverted comma divo, Kefatullah, and whereas in another document, he was shown as Kematullah, Kema at a Kefa. And the aforesaid difference was held to be a discrepancy of fatal nature, so as to discard the burden discharged by the proceeding. But the Supreme Court made its observations that such minor differences, either in the spelling or where is the age one? Another one on age. There is a specific judgment on age, which says that voters list in India, they have variation in the age indicated. It is there. Full stop. In another proposition of the Supreme Court laid down into blank 3D, a judicial notice had been taken that there may be variations in the age indicated in the successive voters list. If it is so, minor variation in the age that may be depicted in the successive voters list is also not to be taken to be a discrepancy which would be fatal in nature, so as to discard the entire burden of proof discharged by the proceeding. That tribunals, while deciding the references made to it, may also take note of the aforesaid two propositions. A copy of this order be circulated to all the tribunals as well as to all the superintendents of police as well as the learned additional government figures who appear before the tribunals. It's a High Court judgment,
Yes,
not Supreme Court.
no, this is not Supreme Court.
No, there is a Supreme Court judgment, if I remember. Mr. Ali, is there a Supreme Court judgment or a High Court judgment?
You know, the judgment, I'll just provide you in Supreme Court itself.
I
In
think
that, in Bihar, there was as regards election, the age of the person was
something like
distributed
that.
as where he was relying on a certificate of birth certificate and electoral roll. There was an observation made
True,
in
right,
that electoral roll, they are not being
think
taken
some-
for.
Two-
I
2 weeks back, I think you produced that judgment also
Okay.
before the.
I will just produce a copy of it. Tomorrow I'll produce the
Yes,
copy.
yes, please. Hetu dito, eto naman. Ito, siya matalaga. Quote ko na lagi. Already dapat. Quote ko na. Refer ko dito. Quote ko na. Anything more you can think of to make the process more purposeful and smooth for everybody? The provisions of this order requiring the procedure to be adopted by the tribunals as well as by the state authorities to the superintendent of police border shall be in addition to all such other requirements in any other law, either statutory or through court pronouncements, and shall not be construed to be derogatory to any such earlier such existing provisions.
Lordship, may I submit? I may be allowed to file additional documents,
Do everything.
voters.
MSD Ghosh,
The demand-
then counter petitioner submits that the petitioner may be allowed to furnish some further materials and documents to discharge a burden of section 9. The petitioner may be allowed if so advised. Issue কৰা হ'ব নহয়। এটা যে মাজত যে blank আছিল, in one of the proceedings before the court, we had the benefit of going through a report being submitted by the state CID, I think your case only. As regards the concept of issuing a certificate by the Gaon Panchayat, Secretary of the Gaon Panchayat. As per the report of the state CID, the origin of the concept of issuing a certificate by the Secretary of a Gaon Panchayat is on the basis of a communication dated 5/5/2015 from the Registrar General and Census Commissioner of India, Ministry of Home Affairs, Government of India, which was issued to the State Coordinator of NRC of Assam, wherein an approved format was provided for issuing certificates by the Secretary of the Gaon Panchayats and executive magistrates for the married women as supporting documents in the NRC process. Accordingly, the Commission Secretary to the Government of Assam in the Home and Political Department, State Coordinator of the NRC, by his communication dated 5/5/2015, addressed to all the Deputy Commissioners, had provided that a certificate may be issued by the Secretary of a Gaon Panchayat in respect of the rural areas and by the circle officers or executive magistrates in respect of an urban area to facilitate the process of NRC in respect of married women who had migrated to a new place by virtue of their marriage. The first paragraph of the communication dated 5/5/2015 is extracted. It was already saying very low. A reading of the first paragraph of the communication dated 5/5/2015 makes it discernible that this certificate to be issued by the Secretary of a Gaon Panchayat is for the purpose to establish a link of a married woman with her parent and her husband, and that it was specifically provided that such certificate shall be accepted only as a supporting document to establish the linkage with the parents. Full stop. A reading of the format provided by the Registrar General and Census Commissioner of India, Ministry of Home Affairs, Government of India, also makes it discernible that such certificates to be issued by the secretaries of the Gaon Panchayat would be numbered with a serial number and date, meaning thereby that the records of issuing such certificates are to be maintained. Such certificates, the dominant purpose of such certificate upon a reading of the format provided indicates that a reading of the format provided by the Registrar General indicates that the dominant purpose of such certificate is that the married woman, as to the place of residence of the married woman after her residence, and also an indication of the identity of her identity with her father and mother and the original place of residence prior to the marriage. Stop. It was a pair of you blank here, select. Thank you. Any more?
In court,
Sorry. That age.
age. I'll just go through one and I'll submit.
Age, one judgment Supreme Court provided that the age provided what it's not very reliable. There is a variation.
One is Sushil Kumar versus Rajesh Kumar. This is indeed just a date of birth contained in voter list and the election identity card are recorded as per statement made by the person concerned. And as such, are not conclusive proof of date of birth. That is 2000 AIR 2004 SCC.
AIR,
AIR 2004 SC 230D.
name of the parties,
Sushil Kumar versus Rakesh Kumar.
Sushil Kumar versus Rakesh Kumar.
Babul Pasi versus state of Jharkhand and Gujarat. That is.
You can give it to the.
Yeah, I'll give.
Yes, Mr. Nath. Anything more to be provided? In other words, we are saying just avoid the,
Unnecessary coming here again going.
yes, it's not serving any purpose.
A fair procedure.
আৰু এটা word দি থৈ আগতে লিখি থৈ দিব. In other words, we also feel that there is a requirement of the tribunals to arrive at a more conclusive opinion being rendered, whether a person is a foreigner or not, rather than an opinion being rendered what word to put. Because if I put a very strong word, it will send a different message. If I use a very light word, it will not have any meaning. I don't want to use that mechanical. So why should I call them mechanical also? They are following a procedure which you feel requires a little bit of further modification. That's all. Sorry. The opinions are more conclusive in nature
This will do.
with reason supported by appropriate materials and documents. Okay.
Search Korea.
Be Islam. Am I Hussein? Your one matter is also there. It will already sign for an amendment. Even कोई भी वो, even कोई भी नहीं. हाँ. Yes, your case is little different. Here, another peculiar problem. Mr. Nath, you cannot leave this court. Here, the problem is there is Order 18, Rule 4. I think Mr. Chaudhary, we asked you in another matter on this question, order 18 rule 4. Evidence by affidavit. Order 18 rule 4. Forget about 16 and 18. The provision providing for evidence on affidavit. Here is a case where here a record to put us. Where the evidence had been rendered. Your microphone is off, Mr. Hussain. Yes, Mr. Nath and Mr. Chaudhary. So the lawyer, what he does, he gives a pre-printed evidence, and whosoever comes, he just asks the name and address and everything, and they fills it up. That way handwritten. He doesn't even bother to put it in a typewritten form also. And file it. So whose evidence is this? It's a evidence by the lawyer or it's a evidence by the witness?
This is why.
Sorry.
This is why.
So that's why I put that question on the other day. On the other day, when I put you this question, there were identical evidences by two different witnesses. Today, we have got a more extreme form that the pre-prepared evidence with blanks all along. When the person comes, you just fill in the name of that man, his address, and file it. It has gone to that stage. To be referring to the Bar Council with a copy of this one, or Hitu ase niki? Hitu konto method ase? Dukhon je identical, DW1 and 2, same affidavit. Should we refer it to the Bar Council, not Bar Council, to that this Law Commission? That the implication of that good provision of 18.4 is leading to this kind of situations. Can we look into it? Should we forward it, making a photocopy of this one from the record?
No. It's, I think the member also should not accept. This,
They should not have been
at the
accepted.
first instance, the member should not accept. This is, it's printed one.
No, printed evidence and affidavit, we also use to file, but it should be for that purpose. No?
This is a form.
This is form.
This is a form.
No, why I'm referring it, should I send it to the Law Commission? That the giving effect to order 18 rule 4 is leading to these kind of situations now.
Perhaps lordship,
We don't observe anything
what,
for their notice that this is happening.
is one part, but, if there is a direction to the members lordship, that affidavits like this.
So therefore, this matter was listed along with Madam Ghosh's matter today.
This, I am holding a similar affidavit here. So, same case, same case with the.
So you are holding the copy of the writ petition, we have handed you over the original record.
In the writ petition, D1 is available, DW1 is available, but DW3 is just DW3. Name is different.
Put the white and is the same.
Non-billing. So it will Raghunath Ghosh, it will Raghunath Saha.
Both of you apply your mind, today is already quite late. See what kind of effective order we can pass.
But
In other words, Mr. Chaudhary and Mr. Nath, we want to reduce we want to bring the proceeding in the tribunal in a given direction. In a proper, that is our purpose.
Lots of them. They have to work in a more effective manner.
Otherwise, it's almost farcical. You can call it.
in any circumstance, this cannot be accomplished.
Everything is happening nowadays. That's why we are concerned and we are trying to pass some orders because it is getting,
No, on the other day when lordship, last time when lordship.
and mind you, these are not isolated incidents.
In fact,
The order that is passed today, it's after a lot of deliberation in almost, I don't know, at least 100 cases. Things are happening like that. One isolation case, no one minds. Something may be an aberration. But when it is the persistent procedure, then it's a matter of concern for everyone. Not for the court, for you also. It
Yes,
should be.
yes. Other day when lordship had taken up this issue, I was not acquainted of this form.
No, that's why today I saw you and thought it should be brought to your notice also. This is what it is. Itu hari video. Day after tomorrow. Huh? This day after tomorrow. You would just apply your mind and tell
Yes,
us what to do.
yes,
You have noticed it. Yes, Mr. Nath, para 97, when to take up that matter? That is another issue.
That is another. But day after tomorrow, lordship.
After tomorrow, we have fixed up that implication of being declared to be a foreigner. We want to.
Right of foreigner, right of,
Right, to be a foreigner.
then on Friday, madam.
Right.
Right.
This 12 is also. And Mr. Chaudhary and Mr. Nath, we need your cooperation in many such matters. We have already, we are trying to streamline the process.
My lord, in item number 12.
Friday.
Item number 12, lordship, regarding that affidavit, lordship. What my suggestion is that if some guidelines are given to the tribunal, lordship, and the tribunals, if do not accept such kind of affidavit, then I think the learned council will.
See, guidelines are given when it is not guided. But when matters are guided, there is no requirement any guideline. It's a requirement for them to act in the manner. The law is very clear. What is evidence? It is section 137 of the Evidence Act. Examination in chief of the fact that the party intends to state before the court. To shortcut the method, 18.4 had been brought in,
in the
that instead of making oral evidence, you file an evidence by affidavit. And that affidavit is ultimately taking this kind of a form.
the present shape. This is not the, purpose.
And not the, mind you, not the isolated case. It's prevailing. That's even more dangerous. We'll just provide on this section 137 and this one something, state the law. These two and the other one, if possible, will bring it to the notice of the law commissioner also, that this is one of the end effects that we are noticing of 18.4.
Mm.
You reject this affidavit. We allow you to give evidence as per law.